Any mention?
Please, Your Lordship, I beg to move a mention memo for listing of an urgent motion matter tomorrow, my lords.
Regarding?
I received a notice from the cantonment authorities for demolition of my building and a notice for determination of my lease. So they're contemplating certain coercive actions against me.
But
The
then
notice
now,
expires tomorrow.
but the thing is that
Correct, my lords.
there's a whole.
developments of
How
excision
would
of
I
the
because
entire-
it was in a civil area.
Lordships in the
The
civil
civil area now, the cantonment, they put on hold everything.
Correct.
Since they're
So
going to
we
hand
don't
it
know
over
why
to
they're
municipality.
initiating this sort of coercion measure against me and selectively only against me for tomorrow, my lords. Highly pledged.
Yes.
May I please, Your Lordship? I beg to mention item 21, Your Lordship. It may come out after a week, Your Lordship.
On behalf of Mr. Qureshi,
Yes, Your Lordship.
Mr. Advocate General is appearing here now.
No, not in this matter.
Take 3 weeks for Mr. Qureshi. Yes.
Highly obey.
Yes, Mr. Qureshi.
Well, I beg to mention number 27. Petitioner.
You have no objection.
No objection.
After 2 weeks, yes.
Thank you.
Yeah, please, Your Lordship. Lordship, I'd like to beg item number 34. It'll be fixed after 1 week, Your Lordship.
Yes?
After 1 week.
Here for the other side. Any urgency in the matter?
No, it is a land for jobs case. It's a land for job case. They have donated land and then now they want job.
You have 2 weeks, yes.
Yeah. Please, Your Lordship, I beg to mention item number 28.
On behalf of Mr. Jha.
Yes, Your Lordship.
Where's Mr. Jha?
He's in Guwahati due to some
He's in?
Guwahati.
He's in Guwahati. Very good. 2 weeks, yes. Yes, Mr. Pathak.
No, I'm told that Dr. Mosika is not around today.
Yes.
Item number 22 and 35, my lord, in that case, my lord.
22 and?
35.
35, my lord.
22 and 35.
Dr. Mosika, I'm told, is in Guwahati.
After 2 weeks, yes. Yes.
Your Lordship, I beg to mention item 23, Your Lordship. This matter
Yes,
is
that's
decided-
connected to 22. After 2 weeks, yes. That's
Your
it.
Lordship, I also beg to mention item number 26.
Yes, 2 weeks, yes. Yes.
Your Lordship, 2 weeks.
These are those education department cases, my lord. Those education department cases, those service matters, my lord.
Yes. That's it.
Lordship, I'd like to mention item number 36.
Number?
36. Respondent number 1 and 2. Conducting counsel, she is out of town, Your Lordship.
Who's out of town?
Respondent number 1 and 2, conducting counsel, Miss P. Bhattacharya. And Lordship, item number 37 also.
Who's
Very
on
for
side 37? We have 2 weeks, yes.
Lordship, 37 also.
Your Lordship, I beg to mention item number 33.
Mr. Yubin is there. Why you want adjournment?
My lord, this instructions that we are supposed to take, whether the application that was filed was in the proper format or not, my lord. What
This is a
happened?
compassion ground.
Yes, my lord. What happened is, my lord, this my clients, one after another, some family member keep on passing away, so he could not take proper instructions. 2 weeks, my lord.
Let's hope we stop passing away. 2 weeks, yes.
Yeah, please, Lordship. Lordship, I beg to mention item 25, Lordship.
20?
25. This is a part heard matter, Lordship, and we require some time, Lordship. I'm praying for 1 week's time, Lordship.
What's the matter about?
This is a teacher matter, Lordship, the termination of the service of this
Isn't that women's college?
women's college.
That computer section.
Oh, yes. No appointment letter.
Yes, my lord.
Right. Yes, 2 weeks, okay.
My lord, I also beg to mention item 29, my lord.
The list is over then.
1 week's time may be granted, my lord.
2 weeks, yes.
Highly obliged.
Yes.
May it please your lordship, I beg to mention item number 30.
It's unending. Number?
Item number 3030.
33.
30, my lord.
Yeah, for the petitioners, my lord.
But there's no urgency in this matter.
Lord, this is regarding that we are certain export obligations which we are required to, my lord.
But Mr. Paul is insisting on hearing last time, I think.
My lord.
Or Dr. Mozia is not here. Okay, 2 weeks, yes. Yes, okay, follow the list.
Much obliged.
Supplementary list, item number 1.
What is this, Mr. Bora? A review of a condition application has been rejected.
My lord, there is no other way.
1087 days. No explanation that you can't supplement your grounds by subsequent application, notwithstanding the incorrect date that has been given, Mr. Bora.
That was because of inadvertence. The juniors prepared it, the petitioner signed, so I also didn't check properly and signed the petition.
And we've not shown any sufficient cause also. That's recorded in the order also. Apart from the errors that have appeared in the application, no sufficient cause. 1087 days is a long time.
My lord, as I had also submitted before, as per judgment of our court only, the dismissal order was on a date when the case was not fixed for hearing. So the limitation as under order 9, rule 9 will not be applicable.
That is in the merits of the case.
Petition is under 227.
Now only why you have come after 1087 days.
No, petition is under 227. There is no limitation. But we
There's 227 section 5. Whatever it is, you have to show reasonable cause for why you've come after 3 years. Oh yeah, 3 years.
I have given the entire revision here also.
Just before we give it a decent burial, we'll just issue notice. Yes.
Yes.
Third, Mr. PK Bora. Issue notice, returnable in 3 weeks. Steps taken by AD within 1 week. This is the first case of a review of a dismissal of a condition application. I think. We make long judgment, it will get reported.
Item number 2.
Yes.
May it please your lordship.
Yes, please.
Lordship, the petitioner in this revision petition is the defendant in a suit which is pending in the trial court. That suit, my lord, has been instituted by the respondent herein. Now, the basic contention in that suit filed by respondent is that there has been encroachment onto the property of the respondent. Now,
by you.
By me. But the point is that there is no nexus which has been brought out in the plaint as to the encroachment and the assertion of the plaintiff that there is encroachment committed by me. If I can just take my lord to
Where's
the
the
plaint. Yes, my lord. Page 23, my lord, is the plaint.
Yes.
Relevant para, my lord, just 1 or 2 paras are important. Para 3, my lord, next page.
Yes.
I'll read, my lord. That there have been some changes in the area of land due to civil suit, donation to the Presbyterian Church, Morprem Shillong, some straightening of boundaries with neighbors for widening the Morprem Road, and by compromises settlement to bring a close a long-standing feud with one Elboris Strawn and ending up in a compromise decree by the learned additional deputy commissioner on so and so. Point being that prior to the institution of the suit itself, there were some material changes in the land. Para 5, my lord.
Yes.
Para 5. That when the renewed patta bearing number so and so was issued by the CM of Milliam in Darbar on so and so, he put the area measuring so and so square feet, deducting the following areas from its earlier land of so and so square feet as per original patta. There is some description. Para 6 is where the problem is, my lord. That some more land was ceded by the plaintiff in between, which was not properly taken into consideration. Example 1 and 2. So reference is made to the patta of the plaintiff by the plaintiff himself, and there is a contention that the patta itself is wrong. Next page, my lord. So after deducting this area, the mission should have been left, not very sure, should have been left with an area of so and so square feet, but as the mission engaged a private but licensed surveyor, namely Bildervaun Engineering Association Shillong, to carry out a detailed survey and to find out the total area that is presently in the possession of the mission, and they found that the total area could be about, not very sure, my lord, could be about so and so square feet, more or less. There seemed to go on, this is where the problem starts, my lord. There seemed to go on under illegal possession by some of mission's neighbors, particularly in the southern side of its boundary, and the area found occupied by the defendants herein is one such trespasser, hence the present suit against the defendant herein mentioned. Now, my lord, I'll just take a pause.
So, cause of action has arisen here.
No, I'll just take a pause.
If you say the defendant herein, the defendant is whom?
I'm the defendant. I'm the defendant.
Okay.
I'll just take a pause, my lord. Firstly, the ambiguity, the unsureness of the plaintiff himself could have gone, should have gone, not very sure. Plaint has to contain factual assertions, my lord, not ambiguities, not conjecture. Secondly, more importantly, on the southern side of the boundary of the plaintiff's land, there are many neighbors. I am one of them. Now, the nexus between the encroachment and myself, where is the nexus, with all due respect, my lord? There seems to have gone under illegal possession by some of mission's neighbors, particularly in the southern side. Why only the southern side? Could have been the northern side, eastern side, western side.
Will it come to para 7?
Yes, my lord. That in the meantime, Mrs. So-and-so and so-and-so.
Are they parties here?
Yes, my lord. They, respectively, with a sinister motive to strengthen their stranglehold in that unlawful possession of the area within the boundary of the Hindu mission, started erecting a pakka-type structure house, keeping for some time under cover and out of sight. But soon this came to sight, and the secretary of the mission addressed a letter to the CM of Milliam to take up a renewed survey and arrange for clearance of the southern side of the boundary of any encroachment, and by measuring the land. FIR was also filed with the Lundinuri police station. The CM of Milliam asked Mrs. So-and-so and Mr. So-and-so to stop construction work, etc. But no heed was paid to that. The police also did not take any step on, only the construction work was ended up. Now, my lord, in this background, I had filed a petition under Order 7, Rule 11A.
For rejection of the
For rejection of plaint for absence of cause of action. Now, that petition, my lord, was filed in 2021, finally disposed in 2023, a few days back. Relevant portion and what I am truly aggrieved with is that page 51, my lord.
It's under 227.
It is under 227, because it is not an appealable order.
Yes.
Page 51, para 28, my lord.
Yes.
The relevant facts which need to be looked into for deciding the application are the averments of the plaint only. On an entire and meaningful reading of the plaint, it is found that the cause of action exists inasmuch as the averments made in paras 5 and 6 of the plaint clearly indicates the area of the property belonging to the plaintiff. Further, paragraph 7 of the plaint clearly indicates the encroachment. Next para, my lord. The encroachment by the defendant in the suit property gives rise for a cause of action to the plaintiff who instituted the suit. Learned Trial Court has prejudged the issue. In the midst of the trial, when evidence is yet to be completed, Learned Trial Court has come to an unequivocal conclusion that there has been encroachment committed by me.
No, maybe it didn't put it in the right way. It should be maybe the alleged encroachment.
It should have been, maybe.
Yes.
But yeah.
Anyway, but the thing is that cause of action is there, Mr. Jindal, whatever it is.
Lordship,
because it's a pointed reference to the defendant with regard to southern. And if, you know, Because I think the bundle of facts.
It is, my lord.
And if the bundle of facts as they present themselves before the plaintiff, they have to present that before the court.
Lordship is very
They can't improve the case by saying that these are the definite boundaries.
Lordship.
So if you are staking your case on, you're basing your case on the fact that this is uncertainty with regard to the area, the schedule, that cannot be consideration in these kind of cases.
Lordship is very right that a cause of action has to be a fact or a bundle of facts. Now, there are no facts, there are only assumptions and conjectures, my lord.
Anyway, I heard Mr. S. Jindal issue notice returnable in 3 weeks. Petitioner take step for issue the notice on this. Only a sole respondent?
Sole respondent.
On the sole respondent within 3 days. Yes. Just thereafter on. Sole.
Lordship, if I can also make another small request. This suit, my lord, was filed in 2008, 15 years back. The only thing that has happened so far in 15 years' time is 3 witnesses have been examined by the plaintiff. One more witness.
When did you file a 711 application? You filed in 21?
In 21, my lord.
Then what are you doing for 2008? You're contesting the suit.
2 things, my lord. Firstly, the law allows me to file it at any stage. And secondly, my lord, we were waiting for some sort of evidence to come on record to understand how exactly is it according to them. We have committed the encroachment.
We'll take it independently. We won't stay the suit.
No, there's no question of stay of the suit, my lord. I was only requesting that if lordship would kindly observe in lordship's order, because what the very real fear is that because I filed this petition, the suit itself will again not progress. We have waited for the 4th witness for 4.5 years.
Yes, pendency of the instant application before this court shall not be a bar on the proceedings of the suit in the trial court.
In an expedited manner.
Item number 3.
Please, your lord.
Yes.
The brief fact is that, my lord, before there's lifetime Gambura was there, headman. After his expires, that the plea of died. Then second one was elected by the villagers. He also expired in the month of June, my lord. Thereafter there was a public meeting, they called. But there is so many candidates, around more than 20 candidates, aspiring for the post of Gambura, village headman.
What's the population of these villages?
Around 8,000, my lord.
8,000?
Yes. Thereafter, my lord, what happened in the meanwhile, some peoples trying to appoint without election or this and that, some vested interested person to appoint somebody. So they have submitted a representation on 7 July, my lord, indicating in page number 18, my lord. Annex 2, my lord.
What indicating what in page 18?
That is these village people.
Demise of Gaupura, Molakandi village, see
Yes.
Abu Bakar,
Yes.
Siddiqui, and the appointment of new Gaupura village regarding a humble request for conducting of election eligible. So, okay, yes. So they're asking for fresh elections.
Yes.
So would this petition in nature of public interest litigation?
No, my lord. That is no. They are the villagers. They have got a right. They are also one of the complainant, my lord.
Yes. Then what did they do after that? This is letter dated?
Yes. And dated is 7th
of
7 July.
Now we only on.
We are still in July, my lord.
No, it is okay, my lord. But in the meanwhile, they are trying
Who's
to.
trying?
That is some vested interested person, few person, my lord, in collaboration with, though I have not mentioned here, with MDC to appoint some particular person, my lord. So that is the grievance.
That is again on presumption.
That is also only presumption.
So you are you asking for by secret ballot election? Or what are you asking for?
Yes. No, I am praying here only my simple prayer.
So now when you elect the Gaupuras by head count or by ballot?
No, not ballot,
Or
my lord.
raising of hands?
Raising the hand only.
Or
In the
those
village,
who
they are
support go to the left or those who support to the right?
yes. Two part they are making like that.
Yes, Mr. Day.
First, my lord, the population is almost 6,000, not 8,000, what my lord
No.
friend has stated. It is in their complaint, my lord. It is not my statement. My lord, may kindly
Yes,
see this third para.
No,
second para.
I have mentioned
6,000, not 8,000, my lord. Second thing, my lord, it is on 7/7 we have received the application, my
Let
lord.
them take instructions.
Let me complete my instruction.
If you notice, Ms. SD is present. We have the respondents and accept notice on behalf of on their behalf. No further notice required. Just after 2 weeks.
Mind, meanwhile, there should not be any appointment. No. Meanwhile,
there should be no elections.
Yeah, there should not be any selection, my lord, not election.
See, Mr. Hazarika, you have gone to this council saying inaction on their part
Yes.
because we need a new Gaumbura, and now you see the Manawar case has come here. There should be no appointment.
In the meanwhile, they may not be.
Where is the prayer, my lord?
Yes, it is there, my lord.
Doesn't matter.
Item
2
number 4.
weeks.
Must
For instructions. Yes.
Please, Lordship.
Yes, Mr.
Your Lordship, this is actually the petitioner. Initially, he was appointed by the administrator, district council run by the district council school run by the administrator. Now later on, the
administrator when
in the 1991 in the Garhis, Lordship, he was a chowkidar, Lordship. Thereafter, what happened because of the Meghalaya overtaking of the district council act, that
taking over, not overtaking.
Overtaking, Lordship.
Taking over.
Taking over. That's because they was the management was taken up by the government. Thereafter, he was retired, and then he has been working after the retirement. Then he was petitioner was later on released from the service after on superannuation on the 31.
But is he entitled to any pension? Was he absorbed
Lordship,
along with
there's
teachers?
entitled earlier occasion because they
There's
have
an order of the court.
there's a Lordship. I will come to that.
You have annexed it?
I have annexed it, Lordship.
Where is it?
Annexed 7, Lordship. And earlier occasion, some people have come, and the same notification, even my name also was there, Your Lordship. Lordship, may I take you to the, just make it a short, Annexed 8, Lordship. Not 8, 9, the judgment from this court only, Your Lordship. There's one person who has come, some chowkidar has come, and he was considered, case was considered, Lordship. The same document is also here. May I read, Your Lordship?
Once again.
Lordship.
Is that been completed? It's not an exercise.
Not it, because
no, there's another case with regard to this, provincialization of whether the staff would be okay taking over.
Yes, taking over
by the government. When it's taken over by the government, whether it'll include the teachers or the staff also. That case is there.
Yes, this spell.
Teaching staffs are also included.
No,
NHS
not
7
teaching also.
They're included now.
May I take it?
As far as NHS 7, his name is there.
So what do you want now with this case?
Now I want that my service also should be regularized, same as like then they should pay the pension, Lordship.
Okay, I heard that the PT Sangma issued notice. MS as well as Raji accept notice on behalf of respondents number 1, 2, and 3, and Mr. K. Compound behalf number 4. No further notice called for. Stop the list. A matter of the 3 weeks for affidavit instruction. Yes.
Item number 7 is a similar matter. Same. Only the petitioner is the disease wife of the disease. That's all. Lordship. Much less, Lordship.
Item number 5.
No, there's an order. There is an order of this court with regard to non-teaching staff being, similarly provincialized among the teachers.
Your Lordship, I will check it.
Yes.
Much less.
Item number 5.
Yes.
Your Lordship, I applied for the post of assistant teacher. There was 54 posts. I was selected. I was placed in the rank of 12. But what happened is that after everything was over, I was placed at 12. I never got an appointment. So what I did, I wrote a representation asking for a reason why I was not appointed. Now
where's the merit list?
Merit list, yes, sir. It's at page 21, Your Lordship. 21. And my serial number 12.
Is there a type copy here?
It's a type copy. It's at page 23, Your Lordship.
Okay. You see, you are selected by selection. Now, the person interview conduct the person teacher and so on. So, the following kinds. Number 12.
Number 12.
Yeah, number 12, right. So 56 people passed.
56 people.
Right. What happened after that?
But I was never given an appointment letter. So I wrote a representation. And in the representation, Your Lordship, which I will take you to the reply which I got from the respondent, which is at page 27.
27, right.
27.
Yes.
Para 1, Your Lordship. It's a fact that the petitioner was recommended. I'll just read it out, Your Lordship.
Yes.
It is a fact that the petitioner was recommended for appointment to the post of assistant teacher in government LP school as per letter so and so. It is also true the petitioner was placed in serial number 12 in the merit list of the declared result of the candidates. With regard to the points number 3, 4 and 5, the name of the petitioner does not appear in the approval list of the candidate for appointment by letter so and so and so. The reason is not known as there is no record available.
Were the other people appointed? But they get appointment letters from the list. What happened to the ones on top of you? Number 1 to 11.
All appointed, Your Lordship.
Appointed?
Yes.
And you were singled out?
Yes, Your Lordship.
Is that a fact?
It is a fact, Your Lordship.
Lordship, if I may take Your Lordship to page 30. Type copy is at page 32. Paragraph 4, Lordship. Paragraph 4. The action of the interview panel to permit the appearance in the interview to the non-DLED candidate is in violation to the appeal committee order, vide number so and so, which stated that all candidates awaiting DLED results from NIOS are also qualified.
You don't have
to
the
apply.
certificate, Mr. Wazir?
At the time of interview, she could not produce the DLED pass certificate, Lordship. That's why she is approval.
No. Listen, it's like this, sir. They have to produce the original DE, whatever it is, ED pass certificate to interview, for which it cannot be deemed as. Did you possess certificate at the time of interview?
At that time, Your Lordship, because of the COVID in 2020.
But do you possess it now?
I possessed it. Last page, Lordship. Last page. 34. Page 34, Lordship. This is my DLED certificate.
Let them consider. If you want merit, it came number 12, and just because there's a slight delay in the certificate.
Some objection came, Lordship, and the inquiry was conducted. The inquiry report is there.
You produce the records then.
No, it's there. Inquiry report is in the petition, Lordship.
You file affidavit. Yes. D.K. Waziri, Learned Counsel for the petitioner. Issue notice. Mr. H. Kharmi, additional senior advocate, is acceptable to have all respondents. No further notice called for. It's a matter after 3 weeks.
Lordship.
For instructions, stroke affidavit.
Item number 6.
My lord,
what is this?
My lord, the petitioners herein, my lord, they are the exporters of boulder stone, my lord, to Bangladesh. They have all the required documents, my lord. But my lord, respondent number 7, who is the private associations, my lord, they have
number 7.
7.
What have they done?
Yeah, my lord, they have made several rules of their own, and then they want to enforce.
What even the rules of their own?
Now, my lord, may kindly see the annex, page number 29, my lord.
Yes.
These are, my lord, kind of slips, my lord, which they are issuing. Different slips at different times, my lord.
What are the dates? This is 2021.
Yes, my lord, may kindly see the other pages also, my lord. Page number 30.
21.
31, my lord. Page number 31.
What is the show the name of people?
Now, my lord, without
22.
Respondent number 7, my lord, is issuing these slips, my lord.
Where is issued under their name?
No, my lord, may kindly see here REMEIA.
Where is that? These don't show anything.
That first.
What are you trying to? You're
my
trying
lord,
to say that.
Page number, yes, they are issuing these kind of slips, my lord, unless and until petitioners, my lord, they take these slips, my lord, from them, they are not able to export these goods, my lord. These are unauthorized.
There's only one page 35 that shows.
29 also, my lord.
The others are all private people.
Yeah, these are all private people. They are the members of these associations, my lord.
How you?
And my lord, may kindly see The orders which I am challenging here, my lord, that is at page number 36 and 37, my lord. Respondent number 2, my lord, here, my lord, the state respondent, they are limiting the number of vehicles also which will ply.
Nasil, they have to limit the number of vehicles.
My lord, this is totally without any rules, without under any, no law, my lord, which authorizes this, my lord.
To stop the amount of export.
My lord, may kindly see, and moreover, and these are being implemented by these private associations, my lord.
Dealing with 475 trucks, I exit respective quarries. 475 a lot of trucks. It's which border port, which custom station is this? Dauki?
Dauki, my lord.
What is wrong with limiting the
And
trucks?
my lord, even the parking also, my lord, is managed by the traffic, parking, everything is managed by the respondent number 7, my lord.
You write the representation before the...
Already complaint has been filed. Complaint has been filed, my lord.
Before the deputy commissioner. This is an administrative problem. It is not a question for writ jurisdiction.
My lord, may kindly see the series of complaints, my lord, which has been filed. Page number 22, my lord.
This is SDO only.
Yes, this has been, complaint has been given to SDO, my lord.
This is 2022. Who are you?
My lord, we are the exporter, my lord. Now here, my lord, unless and until we obtain...
Are you trying to make out a case that there's some sort of monopoly by this?
Right, my lord, and we are not able to export, my lord.
If you can't break that deadlock, then you are limited in activities.
My lord, what is happening is because, my lord...
Is some kind of extortion going on?
Extortion, and my lord, this has been totally controlled by the respondent number 7 in my petition, my lord.
Extortion is going on?
Yes, my lord, these are...
Then have you filed proper complaints?
All these are complaints, my lord. Even FIR also was filed, my lord.
You mean to say that the administration has given a certain direction regarding limiting the number of trucks that cross the border to export limestone, correct?
If it is applicable for all.
Number two is that, okay, there's certain other directions. And you mean to say that this number 7 is implementing those directions?
Right, my lord. That is my only question, my lord.
Your Lordship, I'll take
instructions. Yes, sir.
Your Lordship, I just want to point out in
yes.
this order that is being challenged by the petitioner, Your Lordship, Annexure 4, page 36, Your Lordship. This is a partial modification, Your Lordship, of an order dated 4th April 2023, which has not been annexed in this writ petition.
We don't have a copy of that one. We have
Very
that
good.
Subsequent.
That works to your detriment. Heard Mr. Ensign Conlon, Council Petitioner. If you notice, MSZE non-country.
For respondents 1 to 6, Your Lordship.
Number 1 to 6. We won't issue react to number 7.
My lord, the 7 is the most important respondent here, my lord. Notice has to go, my lord.
We haven't admitted your petition as yet. Let them come instructions after 1 week. Yes, notice to 7 to be kept in abeyance for the time being. Jilan GA to obtain instructions. Listen after 2 weeks, yes.
Item number 8.
Please, Your Lordship.
We are here before Your Lordships on a limited issue, Millets. This pertains to, Millets, the appointment in the Department of Zoology, Millets, in the Northeastern Hill University. Millets, some online application, Millets, advertisement was issued on 16/3/2022, which Your Lordships would find at page 33, Millets.
Okay.
Again, serial number 13, Millets, if Your Lordships have it. Your Lordships will see zoology, Millets, professors. There are 3 posts. One is unreserved, one is OBC, one is EWS, Millets, and the specialization on the last column, Your Lordships would see, one is aquatic biology, stroke fisheries. Number 2 is, my lords, animal physiology, molecular biology. Number 3 is, my lords, biosystematics, animal ecology, and entomology. Now, these were the requirements, my lords, under the advertisement. Now, what has happened, my lords? I am an associate professor in the Department of Zoology in Nehu itself.
Okay.
I have also applied, my lords, for the post of professor. Now, when we went in for the personal interviews, my lords, what we found, my lords, very shockingly, and I'll...
It's over a personal interview.
Personal interview is done, my lords. Now, what we found very shockingly, my lords, and we've given a chart. If I can very quickly take your lordships to the chart, my lords, your lordships would find it at page 16, paragraph 12. Now, these are the credentials of the private respondents who are there before your lordships, my lords.
16.
My lords, page 16, if your lordships have, my lords.
Yes.
My lords have it. We've prepared a chart, my lords. First person, my lords, is one Dr. Timir Tripathi. Now, this gentleman, my lords, his educational qualification is, my lords, MSc in Biotechnology, PhD in Life Sciences, my lords, research specialization, molecular, structural, biophysics, computational biology. So, my lords, there is no zoology background. Similarly, my lords, at serial number 2, your lordships will see BSc Chemistry, MSc Chemistry. Number 3, my lords, MSc Biochemistry, PhD in Biochemistry, Nehu, my lords. And at serial number 6, my lords, your lordships will see MSc in Bioinformatics, PhD in Biotechnology and Bioinformatics.
Is that number 6?
At serial number 6, my lords. Of course, the others, my lords.
What about number 5?
It's zoology, my lords. MSc in zoology.
So you have no quarrel number 5?
Lordships. Now, the eligibility criteria, my lords, in terms of the advertisement, my lords.
Yes. What about number 7?
Again, MSc in zoology, my lords.
It says
MSc in zoology.
Desirable.
I'm sorry.
Yes. Professor, aquatic biology, fisheries, animal physiology, specialization.
My lords. Now, the advertisement, my lords, what does it say? I'll quickly take your lordships to the advertisement as to the... At page 36, your lordships will find, my lords, other terms and conditions at serial number 2.
Yes. Yes.
My lords, the eligibility criteria of candidates and other terms and conditions shall be as per the UGC regulations of 2018, AICT latest regulations as the case may be, and their subsequent notifications guidelines, if any. Now, these notifications, my lords, your lordships would find at page 42, my lords. Now, the first essential qualification, my lords, is at 3.7.
Yes.
The PhD degree shall be mandatory qualification for appointment and promotion to the post of professor. Your lordships have it, my lords, 3.7.
Yes, yes.
My lords. And I will then take your lordships, my lords, at page 43, down below, my lords, for the post of professor.
Yes.
My lords, it says an eminent scholar having a PhD degree in the concerned allied relevant discipline and published work of high quality, actively engaged in research, evidence of published work with minimum of so and so. So, my lords, my humble submission before your lordships is, for the Department of Zoology, my lords, the basic criteria would be that you must have zoology as one of your primary subjects.
A PG or a PhD.
PhD,
Right.
PG, something should be there, my lords. Your lordships will see people from chemistry background are actually being called for a personal interview for appointment as a professor.
No,
in the
but
department.
any relaxation or any...
My lords, it provides that for the relaxation would have to be made only and only by the, my lords, UGC, and otherwise the NEHU ordinances provide, my lords, that cannot be relaxed. I can take your lordships very quickly to that, my lords. Your lordships would find it at page 40, my lords. These are the NEHU ordinances, my lords.
That is at...
Page 40, my lords. It starts from page...
This is 7.
Page 38 onwards, my lords. This is OE4, Ordinance 4, my lords. And I can quickly take your lordships, my lords, to OE 4.3.F, my lords. Your lordships will find it at page 40, down below. 4.3.F, my lords, at page 40.
No, that's not F. That is 7.
My lords, I'm sorry. 4.7 point Roman 3 point F.
Right.
My lords, the qualifications advertised in the notice shall not be relaxed unless the fact that qualifications are relaxable under special circumstances has been mentioned in the advertisement.
Yes.
and the basic academic qualification shall not be relaxable. In case of a candidate who does not satisfy any one or other of the essential qualifications like experience and yet recommended for being called to the interview, the fact shall be specifically stated and reasons for relaxing the qualification will be given in writing.
Now the VC has a discretion to relax the as per 4.
My lords, it is not the VC, my lords, it will be the committee. Okay. There is a committee which is constituted, my lords, for the purposes of making the recommendations. So if the recommendation is there, my lords, and there is any kind of relaxation, it would have to be specific to that person as to why it has been done. But
So
otherwise, your
how
lordship.
come upon information that these other people who have been called for interview are not qualified?
I'm sorry, my lords.
How did you come upon information?
My lords, because when we went for the interview, my lords, all of us were there together. And when my lords, there was interaction, when we found out that from which department, as your lordship would have seen, there are people not only from Nehu, there are people from outside.
No, but you accessed their documents.
No, my lords, we had a physical interaction with all of them.
How do you know that? How do you?
My lords, what I'm instructed, my lords, is that their academic qualifications are otherwise available on public domain.
Okay.
These are available on public domain.
So they were called for interview. When was the interview held?
7th, my lords.
So when the results due?
They've not mentioned anything as yet. 27th, my lords, the EC meeting is likely to be, my lords.
Yes, Mr. Sen.
Yes,
what is the problem here?
First thing, your lordship has already asked that question, my lord. Where from he managed to get these informations? No document has been attached. His only contention that he was also screened, called for the personal interview. He went for the personal interview, and by virtue of interaction, he came to know this is their qualification. My lord, that cannot be accepted, your lordship. Secondly, my lord, this is absolutely premature. Just a selection has been held. Now recommendation has been made. I do not know, my lord, what are the recommendation, because there are people, admittedly, who are also geology, my lord, PhD with geology. At least I have looked into 3 to 4 candidates are there. Now, who are selected, my lord, who are not selected, as of now, I do not know, my lord, the recommendations are there. So, my lord, this is absolutely premature. Only on the interaction that some of the candidates are not from the geology background. That is the contention of my learned friend. There is no document.
There are troubles of court also, because selection process already.
This is premature, your lordships. Nobody has been.
My lords would kindly appreciate. I would have a difficulty.
What kind of order do you think this
court should pass
to protect interests?
My lords, I am.
Your legitimate expectation.
My lord, no, it's not a question of legitimate expectation. No, I am not saying that is not my prayer.
That cannot be a prayer also.
My lords, that's not my prayer. Yes. What I am saying, my lords, is that any kind of selection cannot be dehorse the rules. And if, my lords, there has been any kind of infringement or infraction of the rules, my lords, that would ensure
I understand what spirit is all about. You feel that this has happened. You've seen the qualifications like a caveat on the EC, like before, like the final selection, that keep this in mind. That is what you.
No, what I'm saying is, man, I have said, my lords, my prayer before your lordships is this: the selection process has to go. If, my lords, you are, my lords,
the selection process is not yet finalized.
The selection, now he's challenging the selection.
No, it's not that, Mr. Sen.
My lords,
the thing is that
that is what is permissible. I cannot come back after the results are declared, which is why it is not premature. I cannot come back before your lordships, my lords, after the results are declared, because then that objection will be tenable.
My learned friend is so confident that he will not be selected. This is absolutely.
My lords, I am willing to take that. I am willing to take the chance.
Absolutely.
Mr. K. Paul, Leonard, Senior Counsel, assisted by MS Adata for the petitioner.
I can obtain instruction manual only this much.
Mr. S.N. Leonard,
1 and 2.
So for standing counsel for Nehu, who's accepted notice on behalf of respondents number 1 and 2. So at this stage, no notice to be issued to the remaining respondents.
Well, number 3 is the UGC.
She's appearing.
Okay, MSP Agarwal is present on behalf of the respondent number 3. Notice at this stage not to be issued to the other respondents. Next forum is sent to come instructions after 1 week.
Within a week, well,
1 week.
It's after a week. Obligement.
Well, it's at least till then they should finalize the process.
Nothing, my lord. He's just taking a chance before the court.
No, my point is, my lords, if your lordships would kindly
be satisfied with notice.
No, your lordships, I am only on this. If your lordships just bear with me for a minute. My lords, I am not asking for a stay. I will rephrase myself. My lords, if the selection process culminates into something, my lords, then the objection that has been raised by my learned friend, my lords, will come back to haunt me. That having participated in the process, my lords.
No. Since you have come at this stage, that you already filed your caveat. That's what I'm saying. It's already a caveat.
No observation
with regard to the selection process. That will be taken into account when the matter is finally heard. It's not that you're coming after the selection process.
Lordships.
Yes, item number 1.
His Lordship. His respondent yet is supposed to file the affidavit.
What's wrong with the
last,
Masaji?
as per the last order, Lordship.
I'm paying for 2 days. Straight I'm paying for 2 days.
2 days.
2 days.
2 days file affidavit.
Yes.
3 weeks time be given, Mr. Kivarji undertakes to file the affidavit. We have to respond within a period of 2 days from today. Yes. Yes, accordingly also.
Item number 2.
These are the batch of matters relating to SC.
Inquiry was conducted as per the order of this honourable court, my lord. Government is supposed to place the inquiry
Where's
report.
inquiry report? In regard to the other case, with regard to this, what's the school?
My lord, this is the Ketadua.
Ketadua. Yes. You've gone to inquiry report?
I've gone through, my lord. Only thing is that, my lord, I could not, my lord, flag mark, and that is the only thing, my lord, because we got it evening yesterday.
Is this Ilia Begum still in service?
Still in service.
She is still in service.
Still in
as
service.
asked.
Who's appearing for Abdul Rafiq? Nurul Amin, who's a petitioner of Nurul Amin?
Nurul Amin?
Nurul Amin, my lord.
You are appearing for him?
There are 2 counsels are there,
Yes, my lord. In some cases I am appearing, and in some cases Mr. N. Sincon is appearing.
Yes.
Abdul Rafiq is a respondent.
A report as directed by this court, by order dated 22/5/2023, passed in Miss Case WC number 64 of 2023 and WC of 264 of 2020 has been furnished by the learned by Mr. K. Government Advocate Stop. The same is taken on board and to be examined. Stop. Mr. Kibarashi to flag the relevant portions of the inquiry report and produce it after 1 week. A lot of orders will have to come because the total khichdi, like they say, yes. Take it back. You see, you mark the findings also with regard to this. You see, what this court has seen just now, that there have been observations with regard to certain people, certain persons and their role in, like, in this entire confusion that's arisen. Like Nurul Amin, it's been shown that he has arbitrarily, deducted the salary of 2 teachers. Then even the role of that Ila Begum.
Ila Begum was the main cause for this.
Perhaps actions be taken against. Then one teacher also signed long suffering also. I thought we've been 2021 as the innocent victim.
They're not getting salary, my lord. Yes. 2 to 7 will go, my lord. Same order will carry for 2 to 7.
If my lord, copy of the report can be supplied, my lord. At least
Not now, Mr. Sinkan. You're in trouble. You're paying Nurul Amin. Yes. Don't ask. Don't jump the gun. Yes.
For the court,
You wait for the orders. Yes.
3, I think. Connected.
2 to 7 will
2
go.
to 7 are connected.
Connect.
2 to 8? Yes, my lord, 2 to 8.
Item
1 week. You just flag it.
Item number 9.
Don't show to them as yet. Just flag it. Then we'll give the maybe a bridge report to them. Yes.
Item number 9.
My lord, we have paid the court fee. We have paid the court fee.
When is that?
Yesterday, my lord. I believe the office noting will be there, my lord. Yes,
Yes.
yes.
Self-deposit office note indicates that in terms of order dated 27/2023, passed in MC bracket FA number 1 of 2021, the maximum court fee 11,000 has since been deposited.
There is
Now, what do you want, Mr. Jindal?
there is one amendment petition which is also listed today. In fact, that is for hearing.
Where's Mr. Sen?
Sanjay is in the other court, my lord.
On to?
He's in the other court, my lord.
Where's the amendment petition? This is MC number 4.
Yes, MC number 4.
What amendments you're seeking?
Yes.
Lordships will have page 13 of my application. This is Miss Case 4 of 22.
Page 13.
1-3.
Yes.
So it's when the appeal was filed, the decree had not been drawn up. There was only a judgment of 17/3/2020.
Right.
So we had assailed that. So kindly see, the existing cause title in my memo of appeal is at 1A of page 13, para 1A. This is the existing cause title. The amendment, well, it's at page 13 of my application, Roman 1A. The present cause title.
Waiting page 13.
That's Miss Case number 4 of 22.
Yes, yes.
The application for
para
amendment.
3, since the decree has been drawn up only after appeal was filed with the court, let's see the said decree be brought on record. Such memo appeals regarding amendment further to areas. Is 1B or 1A?
1A and 1B.
Okay.
So 1A is the existing cause title.
Yes.
This is sought to be amended.
Yeah, judgment ordered 73/2020.
So it will mention judgment and order dated
Now you see the
17/3/2020
appeal
and
64.
decree.
Yes, and decree, right.
that
Judgment
is
and order and decree pass on date so and so.
Logic.
Right. That's all.
No,
And
thereafter.
Then?
Kindly see page 14.
Yes.
Amendment to para 1 of the memo of appeal.
Yes.
The existing one
Yeah.
has been indicated in para 2A. Para 2B is the proposed amendment. What we're only including is the expression "and decrease" appearing on the third line of para 2B.
Yes.
Similarly, at page 15, Lordships will find the enclosures originally mentions only judgment. This will mention judgment and decrease in the third line.
And a prayer, consequently.
Lordship. And lastly, can we see Roman 3? There was an objection raised with regard to the valuation.
Yeah, that's been settled also.
Lordship.
Yes.
And finally, the prayer at para 4B. Now, there are a couple of objections that have been raised by the respondents.
They file a written objection.
Lordship.
Objection. Which part of the prayer?
Lords, will see the first objection is at page 3 of their
Yes.
So it has been contended that my application for amendment does not lie under Order 41 Rule 3. They've gone on to say that it would lie under Order 6 Rule 17. Well, in my humble submission, this would be only a case of misquoting of the provision of law, if at all. It would not be fatal to the.
Consequential, yes.
It will not be fatal. It does not result in rejection of the application.
What would they say? Rejection is also. Yes, Mr. General, apart from that, any other objection?
The second one, I'll just come to that. They're saying even if it was covered by Order 6 Rule 17, then the proviso to the rule provides that in the event the trial has already commenced, an application for amendment would not lie. That's my humble submission. This is a memo of appeal. That would not really be applicable here. Moreover, the question in regards to Order 6 Rule 17, what would be the stage of commencement of a trial is pending determination before the Honorable Supreme Court. I have a copy of that as well, although it will not be applicable.
No, but even though it's like that, see, it has the trappings of suit, but you can't lose sight of the fact that this is under the LA Act.
So order section 141 provides that every single provision provided under the code will apply as long as it is not inconsistent.
Yes.
So it will apply to the memo. Now the question of commencement of trial becomes inconsistent with the memo of appeal. There is no commencement of a trial.
No, see, Mr. General, why you make raising objections? Yes, it will not affect the appeal at all. It's not a question of changing the entire nature of the appeal or the memo of appeal or the issues that will be decided. The basic thing is that they've come against the enhancement. That's all. We're going to look at whether that's justifiable or not.
No, that's to your lordship.
Then, and if the decree was drawn up after the appeal was preferred, but
Yes.
then come against judgment order, decrees were drawn up subsequently.
Yes.
So it's in all fairness that they have to include a decree also.
At the time of filing appeal, at least they should have gave a liberty to file the decrees. Now, in the instant case, what has happened, when they filed the appeals, they filed only against the judgment and decree. No,
Judgment
not
order.
decree, judgment and order.
Yes.
Not against the decree.
Because there's no decree existing, because it escaped the mind of a trial court to drop the decree.
At the relevant time, it was not. It was not. It was not. But there is an order in the judgment itself that prepared the decree. So at least the appellant knew that one day or the other, the decrees will be prepared. And even when the decrees were prepared, Your Lordship, they took 6 months' time. 6 months' time, and moreover, Your Lordship will find I am required to meet entirely a new case now. Earlier, I was required to meet the judgment and order. Now they are filing the appeal against the decrees also. I am required to meet entirely a new case.
How will you mean entirely new case?
No, decrees, Your Lordship, include so many other things also. And moreover, Your Lordship, this petition itself is not maintainable. Because
Then I suggest you can go higher. We will dispose of this matter.
yes. Because I have filed one question of maintainability, and that becomes infractious, Your Lordship.
Yes.
That becomes infractious.
That is
And as a matter of fact, Your Lordship, in order to cover up those things which I raised at the initial stage.
Mr. General, I don't think that is the intent. The thing is that we all know when this matter was taken up, the decree was nowhere.
Yes,
Yeah, that
Your
is
Lordship
correct.
is absolutely right. But since I have filed the maintainability question, it becomes necessary for me to file the objection. Otherwise, my maintainability issue becomes infractious. Totally infractious.
Let us, because you have filed cross appeals also. Let
I have filed the cross appeal also, and there are some independent appeal also which are filed.
Let us tackle the
which are
the
filed.
case on the meat of the matter, not on
Yes,
technicalities.
Your Lordship, only a thing, I am not in a position to concede it. And second thing, Your Lordship, there are number of people who have died and they are substituted. When he files the amended plaint, he should include all those people, those who have.
No, of course, that
And update memo of appeal should be filed along with the related annexure, and requisite copies should be served upon me.
That is incumbent upon him to do that.
No, only it may be indicated in the order.
Yes, this is Miss Case number 4H 2022 and FA number 1 2022. This application, this Mrs. application under Order 41 Rule 3, that is Section 151 CPC, has been filed seeking amendment of the memo of appeal. Stop. The grounds as set forth that have necessitated the amendments is as submitted because of the fact that when the appeals were preferred, only judgment order dated 17/3/2020 passed by the reference court bracket Court of Special Judicial Officer, Piboi District at Nongpo was in existence. So, next paragraph. An objection has been filed to the proposed amendments on the ground, firstly on the grounds that the amendment application has been filed on a wrong provision of law, inasmuch as the memo of appeal has been returned to them.
Yes.
Because that's, I think,
That would be in a case if the grounds are sought to be altered.
Yes.
If there is we are not seeking that.
Oh, no? Under wrong provision of law and should have been preferred under Order 6 Rule 17. Stop. And as such, Order 41 Rule 3 will have no application in the instant as in the prayer made by the appellant. Stop. Further objections has also been raised by the learned senior counsel for the respondents that with the inclusion of the decree, the entire dimension of the appeal will change, as much as other grounds will have to be taken by the respondents in defense of the judgment and decree since passed. Next paragraph. Peruse the applications and also the objection made by the respondent. Stop. Next paragraph. Stop. Next paragraph. It is undisputed that at the time when the appeal was preferred, the judgment or the decree, which was drawn up subsequently, was not in existence. The amendment sought, as indicated in para 3, see, Mr. Sen, I think that, it should be 1A. See what your page 13 in the court's copy is 1B and 2B only.
I just see that much.
Yes. That's why referring to 1A. 1A is not here. It's unamended is 1A and amended.
It's this first one. I think there's a problem with the printout, Milad. This should be 1A and the second one should be 1B followed by 2A and 2B. Okay. It should be 1A and 1B.
You just correct it. We will not indicate it. And just sign below.
Lordship.
What the decree which has been not was not the decree was not in existence as it was drawn up subsequently. Stop. The amendments sought are indicated in para 3 of the application. More particularly, para 1B to substitute para 1A that has appeared in the original memo of appeal. Stop. Similarly, the same is repeated in para 2B and it will be
2B.
It will be 2A and 2B.
2A, 2B, followed by Roman
2A,
3 in
2B.
page 15.
Then page 15.
Page 15, Roman 3. This will be an additional paragraph.
Yeah.
With regard to valuation.
Yes.
And lastly, Milad, the existing prayer is.
Listen, one second. Similarly, for para 2A to substitute by 2B. Stop. Further amendment sought is for adding of additional paragraph in the memo of appeal as para number 7, which is given in para Roman 3, 1, 2, 3, capital Roman 3. Stop. Amendments have also been proposed in the prayer. Where's the amended prayer?
At page
Which
17,
has,
4B.
17, which has been indicated in para 4 capital B. Stop. Stop. Next paragraph. It is noted that the amendment sought specifically refer to the decree that has since been passed, and the fact that the petitioner has sought amendment of the memo of appeal at the very initial stage. There's no impediment or will it affect the course of the proceedings if the amendments are allowed. Stop. Next part, notwithstanding the objections that have been raised, the amendments as prayed are hereby allowed and directed to be incorporated in the memo of appeal. Stop. Petitioner to take appropriate steps
Your
for
Lordship,
filing the recast.
Some people have died. He will
Yes, I'll
incorporate.
indicate that to file the recast a memo of appeal. Stop. This court also directs the petitioner to include the names of all the substituted respondents. Because how many have been substituted? No idea.
Around 12 to 14, I think.
Yes, who have been duly substituted by orders of this court, passed in various misses applications. Next, a copy of the amended appeal.
Requisite. I got so many people.
To be supplied to the parties, all parties concerned.
This exercise will take time. If I have to supply so many copies,
Yes, sir.
no,
But it's allowed 3 weeks time.
3 weeks.
In this case, also this is allowed in this court. Yes.
After 3 weeks.
Item number 10.
What correct order in the notwithstanding the quotation of everything, which will have no material effect.
Please, Your Lordship.
Yes.
Your Lordship, I pray for 1 week's time, Your Lordship, to file an affidavit in opposition.
What's the matter about?
Your Lordship, this is a matter pertaining to constitution of school managing committee.
You are for the school.
I'm for the secretary, Your Lordship, secretary of school.
You are F. Langbang.
GC Marbo.
Oh, sorry. Yes. So and so prays for the 1 week's time file affidavit. You file affidavit.
11.
Please, Lordship. Lordship, I pray for the 3 weeks time to file for rejoinder.
How many times you prayed?
This is the second time. Only after recently they have filed the affidavit.
So you don't have anything to reply. That's why you're not filing the agenda.
No, we will be filing with Lordship because there's something more.
Mr. P.D. Samba prays for the 2 weeks time file the agenda. No more time after.
Lordship.
12.
Much blessed, Lordship.
Where's your objections?
We are not filing any objection, my lord. It is a review, my lord. Here, only the order of this honorable
Then
court.
why do you pray for 2 weeks time for objection?
I have taken the instruction, my lord. Didn't want to file any objection.
Yes, Hassan?
My lord, I'll file objection.
When?
My lord, kindly 2 weeks time may be done. I'll just receive the papers, my lord, the tracement, my lord. Because there is the review petitioner, the disputed land is a different matter. What I have.
What do you mean by the disputed
lord,
land?
The previous writ petition, what I come before, the land is different. Now they have mentioned in the review petition, it's a different land.
Oh, that's important.
Yes, the number of
File within 1 week.
My lord.
Within 1 week.
My lord.
2 weeks further time allowed to respondent number
4.
4 to 5 objections. This thereafter. You also get instructions with the Sapa.
13.
Well, this is a matter. Well, it's simply praying for an expeditious disposal of the
Yes,
file by us.
Why are you stalling the proceedings?
No, I'm not stalling. It's quite the opposite. Their application is a case of suppression of vital facts, my lord. This application was filed on the 7th of July 23. It was moved on the 11th of July 23. Now, well, it's on 18th of May. They had filed an application for dropping their witnesses. And they accuse that it's because of the system that the case is being delayed. Kindly see this application. No mention has been made of this application.
18th of May.
18th of May. And we were not supplied with a copy. This case was listed on the 18th of July for cross-examination of PW2. On that date, we received it. On the 18th of July. Now, they could have enclosed this application along with their main revision application. So they want to drop the entire list of witnesses and substitute with 2 new witnesses.
What is that?
Well, it's
See,
again an
original list of witnesses
attempt
are
at
about
our
4.
end, well, it's to basically expedite the trial.
No, this
No,
cannot
but,
be
no,
true.
but the thing is that, see, Mr. Paul, if you are seeking, other orders like, for dropping this of inclusion of new witnesses, this has to be taken up again. That will cause delay to the trial as it is. Your ground here is what? You say that when did you file a suit? You filed a suit, right?
Yes, Millet.
No,
I
they
have
filed a suit.
I filed
For
a suit in
eviction
2018.
and the
Millet.
tenant.
2017, Millet, it has been filed.
2017.
Millet.
Now, what stage is it?
For
Stage
evidence
of
of the
evidence
PW2, they produced a completely new witness who was not in the original list. So the court refused to accept it. So they requested the court to grant them time to file an appropriate application. This application was filed only on the 18th of May 23.
Yes, Mr. Paul, we have to say about this.
PW1, the cross-examination was over as far back as 14th of February 23. They filed this application on 18th of May 23. They can't accuse us of stalling the case.
Where they made the allegation?
The allegation is not against my learned friend's client. We're only saying, Millet.
Now, what happened after any orders passed this application?
No, we received
This
it
is
only
not
on the
taken up
18th
as
of July.
evidence. What had happened, this application is filed, Millet. The copy for the respondents was filed along with it in court. They have received it only on the last date.
They could have
Last
supplied
date
a
was
copy
when?
in the month of May
Millet,
itself.
this is of no relevance insofar as the suit is concerned, Millet.
No, of course it is, Mr. Paul.
Millet, because
The thing is
if
that
we
you're seeking
are only
introduce-
wanting to
if you're going to
pun the
introduce
witnesses.
new witnesses, of course, it will have an effect
Millet,
of proceeding.
we are dropping witnesses. They are my witnesses.
You're not substituting them.
No, they are substituting Millet. They provided two new names.
Two new names because of the reason, Millet. Your lordships will kindly appreciate what the grounds on which these applications have been filed, Millet. That when the suit was filed, these witnesses were there, available. Now, one of them, Millet, has suffered some serious medical ailments, Millet. He is not in a position to come before the court. That the court can consider, Millet, at an appropriate stage.
Take down here, sir. This application will be filed under Article 227, seeking expeditious disposal of title suit number 11, bracket H 2018.
17, Millet.
17. Strong issue in the prayer pending before the United Assistant District Judge Long. Stop. The reasons as set out is that due to the long delay, caused in disposal of the suit has caused immense hardship to the petitioner. And due to the delay, the witnesses who are supposed to appear have not been able to tender the evidence. Stop. Mr. K. Paul submits that appropriate orders be passed directing the trial court to expedite the matter. Inasmuch as to expedite the matter. Stop. Mr. SN was under appearance on behalf of the respondent. The first appearance he made today itself submits that the delay that has been caused cannot be attributed to the respondent defendant. As much as recent as on 18th May 2023, an application under Order 16 Rule 1 Sub Rule 3 has been filed by the plaintiff to allow additional witnesses and for dropping 2 witnesses who are already a list of witnesses. He further submits that a copy of the application was made available to the respondents only on
18th of July, my lords.
18th of July.
They received it on 18th of July.
Yes.
We had filed it earlier.
Only on 18/7/2023, which was the last date. As such, he submits the delay not being caused by them. The application is devoid of merit and no interference is called for. by this court. So, having heard and counsel with the parties, it appears that the only concern of the plaintiff petitioner is that the suit proceed in the expeditious manner. As the petitioner, how old is the petitioner now?
She will be.
The petitioner be of advanced age.
She'll be about 70 years old.
Being of advanced age, will be not in a position to enjoy the property for which she is seeking eviction of the defendant's stock. Though no specific allegations have been made that the respondent is the cause of delay, and that the only reason shown is that the long dates that have been fixed by the trial court. In this court, at this stage, deems it fit to dispose of the instant application with the direction that, notwithstanding the applications that have been filed, the trial court shall endeavor to dispose of the title suit, which is stated to be at the stage of
Examination, cross-examination of PW1.
PW1.
No, that's over.
As expeditiously as possible.
Examination of witnesses, I stand corrected.
It will have as soon as possible. Stop. With the above directions, matters stands closed and disposed of. Not giving any time.
Your
lordships have said expeditiously, my lord.
14.
Obliged.
Hearing number.
May it please your lordship. Lordship, this is that legal aid matter where the petitioner was electrocuted, lost his hands and legs. As per lordship's last order, respondent MECL was directed to pay the compensation.
Paid.
Oh, we have sought
May please, your
for...
lordship.
Who's that?
Lordship, as per the order dated 24th July, we had complied with the order and were ready to pay the compensation as per the notification dated 19 August. If my little friend can hand over the papers, Lordship, the reply along with
It's a
the
real streaming video. You see?
My apologies.
It's really streaming down the screen.
My apologies.
You give a copy to the petitioner.
I've just received a copy.
So, Lordship, as per the scheme, as per 1B3,
yes, 1B3. 1B, A, B, C.
Lordship, there are 4 columns. The 4th column will be limit of ex gratia compensation to victims of
It'll be 1,50,000.
Lordship.
He lost both his arms and legs.
He's lost both his arms. Lordship, if I can clarify, because the video is not very clear, I am covered under the 3rd column.
Yes, 3rd column.
Injury requiring hospitalization. If Lordship reads, hospitalization of more than 7 days, my case, rupees 10,000. Lordship, my hospital bills, my claim is 13 lakhs.
No, it's 1B3, not 1BC. See this, it's the 1B3. There's one up to 40% 50,000. 40-60% rupees 1 lakh. 161% rupees 1 lakh.
Lordship. It comes to 1,50,000, my lord.
Yes.
Now, Lordship, my 2 things, my lord, if Lordship permits. Firstly, this notification or this scheme does not apply in my case. As
It doesn't apply, but it's by the court order that at least you pay something now. So
yes,
we'll examine that later on.
Yes, my lord. Yes, my lord. The second aspect, my lord, is that lordship would have noticed my claim as far as the hospitalization costs are concerned is about 13 lakhs, my lord. Now, the claim being 13 lakhs and supported by bills, there is no dispute about the bills. My claim for the moment is only for the hospital bills. I'm not claiming any other under any other head. Now, but bills being for 13 lakhs and I'm being offered 1,50,000.
No, 150 is as per the existing scheme. It's not a question that they have fixed that amount.
Yes,
correct.
Yes, my lord. But this, my point being, my lord, with respect, scheme itself does not apply to me.
Does not apply. That's what they said the last time also. They did not give ex gratia payment because the scheme does not apply.
Yes, my lord.
But the court said at least for some relief to
Yes,
you
madam. Yes,
that
madam.
you be paid something.
Yes, my lord.
Where's that order dated?
Lordship's last order on 26th June, my lord. Second paragraph. Court notes that the factum of the incident that had occurred is not disputed, and also for such incident, compensation is to be awarded appropriately. Accordingly, the respondent corporation is directed to dispose of the representation and to accord appropriate compensation.
Okay, Mr. H has gone along with S. Ladu. Today has produced a letter dated 24th July 2023, wherein it is indicated that the respondent corporation is willing to pay compensation in line with the government notification dated 22nd July 2020 in connection with the electrocution case of the petitioner. Stop. A copy of the said letter has been made over to the counsel for the petitioner. Stop. Next paragraph. Mr. S. Jindal, counsel for petitioner submits that it's an admitted fact that the incident had occurred before the advent of the scheme, and his claim that the petition is for an amount over rupees 13 lakhs, which had due to the hospitalization of the petitioner. So, he further submits that as per the scheme, the petitioner will be entitled to only rupees 1,50,000 as per the office memorandum dated 19 August 2022. More particularly at 1B Roman 3, small Roman 3. He further submits that this amount will be accepted without prejudice to his rights to further claim of compensation after hearing of the writ petition. See, you take it without prejudice, and then you can reserve your right to agitate for. To reserve his right to agitate for further compensation in the incident petition.
So, respondent may file an affidavit if they so choose.
No, you've given that. Then you come back with the doctor's things they've given. When can you pay the amount? At least 1.5 lakhs.
Lordship, as per the order, they have to provide the doctor's certificate and proof of relationship and the bank details, and then we shall release the amount, Lordship.
Yes. The next Ms. H. Karwanda, the counsel for the respondent corporation submits that on receipt of the documents as specified in the letter, the compensation of 1.5 lakhs will be released immediately. Just after 3 weeks.
Obliged. Highly obliged.
Obliged.
Item 15.
I'm praying for some time, my lord, to file the reply, my lord. Here, my lord, they have challenged a notification by which the gratuity and the leave salary is calculated. My lord, because of session, the thing cannot be discussed in the EC, my lord. So I am praying for some time.
Because of session?
There is session going on, my lord. The EC, they are not taking up the matter, my lord. Lordship. My lord, I'll pray for 3 weeks so that I can file it within 3 weeks.
May they please for not for the 3 week time to file affidavit. This afterwards.
16.
Authorised, Lordship.
My lord, here the petitioner, what the instruction I have received, my lord, I will file an affidavit. The petitioner is the brother-in-law of the private respondent who is running the fishery. He's a own brother-in-law, and his prayer is this: that there should be a tender, fresh tender. Earlier, as per the order of this honorable court, we have divided into two. We have divided, my lord, the term of the period, my lord, to petitioner and to the private respondent, my lord. Now they are challenging that no, there should be a fresh tender.
No, you mean to say that
Earlier
it
there was
says
a-
collusion?
Sorry, my lord.
It says collusion between.
Yes, definitely, my
But how
lord.
do brother-in-law? How can suppose they might not be in good terms?
My lord, that I have no comment, my lord. But I was instructed, my lord, that
that
he is the
correct?
own brother-in-law. Own brother-in-law, my lord.
Lordship, I have to seek instruction. Let them file the affidavit.
We'll
Your
file
Lordship.
our affidavit.
If it's your brother-in-law, why not appearing? Why not appearing in court? You'll accept notice on their behalf also.
No, Your Lordship.
Just in jest.
They'll come after 3 weeks, my lord. We'll file our affidavit, my lord.
3 weeks too long.
But it is a fishery matter, and private respondent is yet to appear even, my lord. Whether they have received the notice or not, my lord.
They have already received.
This one number 5 is brother-in-law.
No, Your Lordship.
Is he a brother-in-law or not?
Number 5
Or,
is...
number 4. Mr. SD, please sponsor further.
Yes, number 4 is the brother-in-law, my lord.
Yes. None appears on behalf of number 4 and 5. Hello.
Obliged.
17.
Please, Your Lordship. Your Lordship, we have filed our affidavit yesterday indicating that the petitioner has received the revised pay of scale as well as the gratuity amount, Your Lordship.
Sir, I will, sir, your lordship, I want some time. I will find rejoinder, sir.
Rejoinder, if they've been paid, now you need instructions only.
Your Lordship, nothing remains.
You have not
in this.
disclosed anything in
No,
the petition.
because I will contact with the client and then...
You have no contact with your client.
Yes, I have contacted with him, but he is sick, no? So he will come, let him bring all the papers.
He's
Please
in
keep
hospital
some.
or he's at home.
He is at home, he is a
So
stroke
you go to
patient.
visit him and take instructions
Yes,
also.
sir.
He'll get well soon. Yes.
Sir, please grant me some
I'll give you 1 week time to get instructions here. MSZE Naukri Leonard J submits that all the terminal benefits as entitled have been made over to the petitioner. The MSS Rahman please allowed to take instructions. This after 1 week. You take instructions.
Obliged, Your Lordship.
18.
Lordship, I'm praying for 2 weeks' time, Your Lordship.
You are for private respondent.
Yes, Your Lordship.
Private respondent number?
State respondent.
You're in the panel also?
Yes, Your Lordship.
What's your name?
A.M. Pala.
KL?
A.M. Pala.
How long you practice?
2018, Your Lordship.
2018.
No objections, Your Lordship.
How much time? 2 weeks.
Yes, Your Lordship.
Mr. So praise for our further energy and then praise for our further 2 weeks time to file affidavit this thereafter and so on.
19.
May I please, Your Lordship?
Yes.
Your Lordship, the last order, Your Lordship was asked us to take steps for respondent number 4.
You didn't take steps, why?
Lordship, I couldn't recollect, so my apology, Lordship. Just give me some time, so I'll take, Lordship.
Officer indicates that petitioner has not taken steps for issuance of notice or upon complaint for stuff. MS Panjam tenders apologies and praise him be allowed 3 days time to complete the same. Stop prayers allowed.
I'm for the state, Your Lordship.
You won't file affidavit.
We'll be filing and praying for some time.
MS I more praise for allowed for the 3 weeks time to file affidavit. Just
I'll
that.
oblige you. Oblige you.
20.
Well, I'm praying for some time, my lord, to file my affidavit. A small affidavit will be required, my lord, in this matter.
Pension matter.
Yes, Lordship.
Mr. SD, please for allowed further 2 weeks time to file affidavit.
Highly obliged, Lordship.
Penpa, Pito Sheik untuk SHEIK, Hawaii Harum Pito SHIEK, Pito E.
Hearing supplementary
1
list.
second, I'll just come back 5 minutes. You're ready with the matter? You're ready with the matter? I'll just come back 5 minutes.
Item number 9.
Yes, Mr. You start fresh again.
My Lord, and before I proceed further, my Lord, there seems to be many other petitions also, my Lord. So what I propose, my Lord, if subject to the acceptance of your Lordship, my Lord, once they are finished, my Lord, I can. Otherwise, I'll have to every time, my Lord, stand up and reply to these things. So if they finish, my Lord, I can sum up thing and reply, my Lord.
Whatever you want to choose, which is convenient for.
My Lord, Mr. Nonklau is there. My Lord, my other friends are also there, my Lord.
Whose other friends?
My Lord,
Mr.
there
Lindu
are
was there
4
also?
petitions.
With regard to the item number 11, I endorse to whatever Leonard Sri has.
No, but which district is your case? Your case in which district?
East Khasi.
East Khasi.
East Khasi. Yes.
All the rest are East Khasi.
East Khasi. 10 and 11. Sorry, Lordship.
You are appearing with whom?
My
Mr. Robby.
My district white.
Where is Walang? Okay.
My Lord, district may not be that relevant, my Lord,
No,
but then
in
even
case they have some issues. That the main missing that is that notification applies to Reboy.
My Lord, so long it is not Garo Hills, my Lord, my submission is that division by judgment will cover it.
Yes, yes.
Okay.
So, my Lord, if my Lord, they all are, my Lord, endorsing the submission of senior counsel,
Yes,
my Lord, then in
as
such a
far as
case, I can proceed.
concern, I endorse.
But if they have anything to add or my Lord, that I do not.
It's all up to you, like I said. How you, which way it's more convenient.
I think that is it. With reference to item number 10.
Item number, wait.
11. 11. 10 is there.
Number 9 is Mr. Changreso. Number 10 is Mr. Kinjing. 11 is Mr. Nongkla. 12 is Mr. You're there. You all are there. Yes.
All are here. All are here.
So nothing else to submit, Mr. Changreso.
My Lord, subject to my Lord's permission, I may give some reply.
Of course, but you have to give. In this case, I want some, because the submission is not based on any pleadings, but point of law. So, yes, of course.
The issue is relating to question of law, substantially, madam. Yes, substantially. Since the learned AHA has started yesterday, let him proceed and give a short.
He start again afresh. Yesterday, he had not, collected his thoughts and his arguments. Yes.
Yes, my Lord, what is relevant is the provision of paragraph 4 and 5 of the 6th schedule, my Lord. Now, my Lord, I had, my Lord, gone through the parts of provisions of paragraph 4, my Lord, yesterday. Now, my Lord, just for my Lord purpose of my Lord refreshing mind, my Lord, if Lordship permits me, I'll just go through it again, my Lord.
Yes.
So, my Lord, there can be, my Lord, word-to-word appreciation. Given so old, there is no need. My Lord.
Yes.
Paragraph 4, my Lord. Are you sure that is correct? Not amendment. Regional 4.1, my Lord. The Regional Council for an Autonomous Region in respect of areas within such region and District Council for an Autonomous District in respect of areas within district other than those which are under the authority of the regional councils if any, within the district may constitute village councils or courts for the trial of suits and cases between the parties, all of whom belong to scheduled tribes, within such areas other than suits and cases to which the provisions of subpara 5 of paragraph 5 of this schedule apply, to the exclusion of any other court in the state. My lord, these two parts would be very much relevant.
Yes.
And may appoint suitable persons to be members of such village councils or presiding officers of such courts, and may also appoint such officers as may be necessary for the administration of the laws made under paragraph 3 of this schedule. Paragraph 2 may not be that relevant, but then if Lordship desires, I can go through my lord, or otherwise I can skip it. However, my lord, other side has nothing to say about that matter. Now, if my lordship come to paragraph 5 of them. Now it says conferment of powers. My lordship will kindly, my lord, take it to note the words used, my lord. The conferment of powers under Code of Civil Procedure 1908 and the Code of Criminal Procedure 1998 on the regional and district councils and on certain courts and officers for the trial of certain suits and offences. My lord, it speaks about the conferment of powers under CRPC and CPC. My lord, CPC right now may not be relevant.
Yes.
Now, my lordship, the starting words. The governor may, my lord. My lordship will kindly take note of the word may, my lord. For the trial of suits or cases arising out of any law in force in any autonomous district or region, being a law specified in that behalf by the governor, or for the trial of offences punishable with death, transportation of life, or imprisonment for a term not less than 5 years under the Indian Penal Code, or under any other law for the time being applicable to such a district or region, confer on the district council or regional council. My lord, that is also, my lord, lordship will see, my lord, take note that confer, my lord, conferment of power, my lord. Confer on the power of district or regional council, having authority over such district or region, or on courts constituted by such district council or any other officer appointed in that behalf by the governor, such powers under the Code of Civil Procedure 1908, or as the case may be the Code of Criminal Procedure 1898, as he deems fit appropriate, and thereupon the said council, court or officer shall try the suits, cases or offences in exercise of the powers so conferred. My lord, may I take, my lord, pause for here. Lordship will find, my lord, it speaks about the conferment of power on the, my lord, the officers of the district council, coastal district council, and thereafter, my lord, empowering them to conduct trial on offences where offences are punishable of more than 5 years. Now, my lord, what is to be noted is there, it doesn't say that to the exclusion of any other court.
Yes.
So,
Yes.
now, lordship may kindly, my lord, come to subpara 2, my lord.
Yes.
The governor may, that is also, my lord, very important. Governor may withdraw or modify any powers conferred on a district council, regional council, court or officer under subpara 1 of this paragraph. Now, my lord, this power is available, my lord. Governor may exercise at his discretion. My lord, it can be exercised any time. It doesn't say. Now, it may happen like this. Why I am preferring this, my lord? It may happen that, my lord, today power is conferred, tomorrow it is withdrawn. But will it mean the criminal justice system will come to a halt?
Yes.
So, my lord, the mere reading of paragraph 5.1, my lord, unambiguously shows that it is only a conferment of power that is thereby, my lord, creating or allowing some authority to, my lord, exercise power simultaneously with, my lord, the courts of the establishment of additional deputy commissioners. Well, those part lordship, my lord, knows very well. I do not have to say all those things. It is only, my lord, only thing is what I wanted to say, that the, my lord, the measure, what they wanted to say, that once the power is conferred, my lord, that would automatically mean that other courts are excluded from, my lord, taking cognizance of jurisdiction, meaning thereby that the would call all other courts becomes a quorum non juris, my lord. So that is not, my lord. My lord, 5.1 is very much clear. Now, my lord, I do not take much time, my lord. So far as my learned friend has referred to some notifications, my lord. So all those notifications, lordship will find this has been referred to before the division bench also, my lord. So I don't think, my lord, reading these notifications all would basically, my lord, create a separate case, my lord. It is altogether, my lord, this is a basic proposition of law, my lord, whether, my lord, that is an exclusive power or not. That is to be determined. my learned friend has basically referred in those notifications to show that certain individual or certain court was empowered, my lord.
What they want to show is that on being conferred those powers, then suits between tribals will exclusively be tribal only with council courts to the exclusion of other courts. While your case is saying that, look, I think the exception is carved out in para 4 itself, that the matter will be to the exclusion of para 5.1, all matters will be taken up by by the district council courts. That is the final distinction.
My lord, the matters falling under paragraph 4, exclusive jurisdiction of the district council, my lord. 5.1 is different. It is not. Now, my lord, I will make your lordship, my lord, to go through the judgment. I will.
Of course, we have to go through the judgment.
My lord, at least, my lord, till paragraph 38, my lord.
Yes, yes.
My lord, on the other day, my learned friend has read only
34 to 38.
My lord, I'll just start, my lord, because according to me, all paragraphs, my lord, some sentences will have some relevancy, so I just cannot leave out these things. Now, my lord, let us start, my lord. My lord, lordship, judgment is your lordship, I think.
Yes, yes.
A somewhat novel and audacious ground has been urged in this appeal. The appellant asserts that the district and session judge who conducted the criminal trial and convicted the appellant and sentenced him to life imprisonment plainly did not have the authority to take up the trial or adjudicate the matter. Now, my lord, may I pause for a second, my lord? If it concerns the East Council in court, my lord, they cannot say that it doesn't have the power to conduct until they said there is an exclusion. My lord, what I am saying that is the conferment of power was not required on those also because they were already having the power. My lord. Number 2, as a result of this frontal challenge to the authority of the district and session judge to take up criminal trials where the victims and accused are tribals belonging to the same tribal area, subsequent appellants have jumped on the bandwagon, if only to delay the inevitable or hope for better weather on the bench. The speedy disposal of the criminal appeals in this court has been affected as a consequence over the last 6 months or so for one or the other reason, and the search for relevant notification published under authority of the governor of the state, a speedier disposal of this appeal was impeded. Now, what is to be noted, their challenge is with regard to the my lord taking up of trials by the other court where my lord victims and accused are tribals, my lord. That is what has been reflected here. Now, paragraph 3. Before coming to the nature of the objections taken by the appellants as to the jurisdiction of the trial court in this case, the special feature of the state must be adverted to. Except for a small pocket in the capital city of the state, which area is known as the European ward in Shillong, the rest of the state is regarded as tribal land. The Khasi and Jaintia tribes occupy the central and eastern parts of the state, while the western parts of the land of the western part is the land of the Garo tribe. Accordingly, there are 3 distinct autonomous hills council. The autonomy of the district council and an independent court structure under them is provided for in the 6th schedule to the Constitution of India. The 6th schedule to the Constitution was designed on the basis of recommendation of the Gopinath Bordoloi Committee set up by the Constituent Assembly. The discussions in courts of the Constituent Assembly debate reveal the history from British time when some of the regions in the northeast were described as backward area and others as partly backward areas. That the Montagu-Chelmsford report later rechristened the less offensive as excluded areas and partly excluded areas. In essence, the 6th schedule mandates that the tribes would be governed by their laws, custom and usage, and disputes between them would also be resolved by village elders or courts set up by their tribal council, except in respect of certain classes of matters. Indeed, for the present purpose, paragraph 4 and 5 of the 6th schedule to the Constitution are of some relevance. For the present discussion, paragraph 4.1 and paragraph 5.1, 5.2, 5.3 of the 6th schedule may be.
Yes.
That we can skip, my lord. Yes. There is no regional council in the state of Meghalaya. As aforesaid, there are 3 district council covering the 3 separate tribes inhabiting the state. Loosely speaking, the area covered by the state was under the original Bengal presidency and thereafter in the province of Assam under British rule, and ultimately a part of the state of Assam in independent India before the state of Meghalaya was carved out in the year 1972. Since 1972, several of the original districts have been bifurcated and further subdivided such that there are now 12 administrative districts in the state. At the time that the constitution came into effect with the 6th schedule therein, paragraph 5 thereof provided that neither the code of CPC or CRPC would apply except as expressly provided in such provision. In paragraph 5(1) of the 6th schedule of the constitution, the governor is permitted to confer such power under either code as he deems appropriate. If further, my lord, may I stop for it? Lordship will say the governor is permitted, my lord. Now it is not that the 6th schedule itself, my lord, conferred the power. So discretion was left to the governor. That is what the words we might have taken notice, my lord. Governor is permitted to confer such powers under either code as deems appropriate. However, prior to the constitution and the 6th schedule therein coming into effect, the previous laws in place, including particularly the rules for the administration of justice and police in the Khasi and Joint Hills 1937, provided that in criminal matters only the spirit of the criminal procedure code was to apply and not the letter thereof. It must be recorded at this stage that the history of the administration of justice is much the same in the Garo Hills, but since, my lord, this also lordship will take concern, since this matter emanates from Khasi and Jointia Hills. Now, my lord, why I am referring it, my lord? Because this judgment covers Khasi and Jointia Hills. There is no further reference to the Garo Hills therein. The said rules of 1937 were notified by the governor of the then Assam province under section 6 of the Scheduled Districts Act 1874, and such rules were to apply to the whole of the United Khasi Hills and Jaintia Hills district, excluding areas which are known as Khasi districts. However, a day before the Constitution of India came into force in its entirety, the Khasi CMC Administration of Justice Order 1950 was issued on January 25, 1950. Such order of 1950 brought within its fold both the areas of the United Khasi and Jaintia Hills district covered by the 1937 rules and other Khasi states. Though the 1937 rules are no longer in vogue, a Supreme Court judgment in so-and-so has recognized that for the sake of continuity, the said rules continue to have effect. Indeed, upon this state being incorporated by the Meghalaya Act number 6 of 1972, 1937 rules have been adopted with effect from February 22, 1972. For the purpose of present discussion, it would suffice to notice that under Rule 1A of the Rules of 1937, the Governor had the authority to appoint an additional Deputy Commissioner, either generally or for the trial of a particular case or cases pertaining to both civil and criminal matters, and for such purpose, the additional Deputy Commissioner would exercise all or any of the powers of the Deputy Commissioner. In due course, the Deputy Commissioners elsewhere in the country came to be recognized as collector and now are mostly known as district magistrate. But in this idyllic state in the lap of nature straddling 3 hill ranges, the custom continues of Deputy Commissioner heading the district. Rule 16 of the said rules of 1937 stipulates that criminal justice shall be ordinarily administered by the Deputy Commissioner, his assistants, and by Sirdars, Dolois, and other chief village authorities of the different communities. However, in terms of Rule 17 of the said rules of 1937, only the Deputy Commissioner had the authority to pass a sentence of death, transportation, and imprisonment up to maximum amount provided for the offence and the like. More serious sentences of death, transportation, and imprisonment of 7 years and more were subject to the confirmation by the then High Court of Assam. Petty cases were to be taken up by Sardars, Dalois, and other chief village authorities as would be empowered by the Deputy Commissioner. An appeal would lie to the Deputy Commissioner from any decision of an assistant. It appears that the word assistant in the appeal provision in Rule 21 covered Sardars, Dalois, and other chief village authorities, in addition to special persons that the Deputy Commissioner could appoint for taking up petty matters. As to the application of Criminal Procedure Code, Rule 23 of the said rules of 1937 recorded that the Deputy Commissioner and his assistant shall be guided by the spirit of the Code of Criminal Procedure as far as it is applicable to the circumstances of the district and consistent with these rules. In the order of 1950 covered, as indicated above, both the United Khasi and Jointia Hills district and also the Khasi states except the municipality of Shillong and the cantonment. Such order of 1950 recognizes Khasi CMCs, where the CMs means a customary head of the Khasi tribal institution of an administrative area of the United Khasi and Joint Hills district known as Khasi state. The said order of 1950 provided for the administration of criminal justice to be by the Deputy Commissioner or Additional Deputy Commissioner and his assistants, as also by the courts of the CMs. Rule 3 of the said order of 1950 extended the Indian Penal Code to the extent it was applicable in the other areas of the state of Assam. Rule 16 of the said Rule 1950 defined the court of CM and its jurisdiction, and sub-rule 2 therein mandated that the court of CM may try any offences under the Indian Penal Code or any other law for the time being in force except those punishable with death, transportation, or involving a punishment of 5 years imprisonment which may arise within the limits of the locality and in which the Khasis who reside or hold land within its locality are concerned. For completeness, it must be recorded that the United Khasi and Jaintia Hills Autonomous District Administration of Justice Rules 1953 came into effect for the entirety of the Khasi Hills Autonomous District, excluding the areas comprised within the municipality of Shillong and the cantonment. Rule 4 delineated that the classes of courts, which village courts at the bottom of the pyramid, subordinate district council courts, and additional subordinate district council courts in the middle of the three-tier system, and the district council court and additional district council court being at the helm. Rule 9 of the said rule 1953 contemplates a solitary district council court for the Khasi Hills Autonomous District. In the dealing with the powers of the court, village courts were not made competent to try offences in respect of which punishment of imprisonment was obligatory under the penal code, as a village court had no authority to pass a sentence of imprisonment, and the upper limit of the fine and it could fix has since been enhanced to ₹150. In respect of criminal matters, subordinate district council code is given authority under the 1953 rules to try all criminal cases not triable by a village court in which the offence is committed within its jurisdiction. The additional subordinate district council courts are competent to try all criminal cases not tried by the village courts in which the offence is committed within its jurisdiction. Some exceptions are made as to such authority in specific instances. The only other provision to note is that under Rule 58 of the said rule of 1950, the said order of 1950 stood repealed. Though the several other sets of rules have been referred to in passing in course of the hearing, the only other body of the rules that may be specifically noticed should be Meghalaya Judicial Service Rules 2006, Schedule A. To such rules refer to a post by name of district and session judge. The qualification for such posts are identical to those necessary for a district and session judge elsewhere in the country. Now, my lord, from paragraph, my lord, what you will find these contentions of the petitioners reflected, my lord. Now, according to the appellant therein, the authority under paragraph 5.1 of the 6th schedule to the constitution has been exercised by the governor in the state of Assam, when Meghalaya was also an integral part of such state, and by subsequent notification after the formation of the state of Meghalaya. The parties have brought several notifications to bear on the issue, beginning the one published in February 27, 1989, which named judges of the Khasi Hills District Council Court was vested by the governor with the power for trial of offences punishable with death, transportation for life, or imprisonment for a term not less than 5 years, under the Indian Penal Code or under any other law for the time being applicable to the Khasi Hills Autonomous District. A similar notification followed on November 20, 1989, by which an additional judge of the District Council Court in the Khasi Hills Autonomous District was similarly empowered, presumably upon the various incumbent appointed by the February 27, 1918 notification demeting office. A further similar notification came to be issued on April 21, 2006 with a named judge of the Khasi Hills Autonomous District Council Court being given similar authority. On April 21, 2006, another additional judge in the Khasi Hills Autonomous District Council Court was also given similar authority. On March 29, 2007, again in exercise of the governor's authority under paragraph 5.1 of the 6th schedule of the constitution, a magistrate in the Khasi Hills Autonomous District Council Court was conferred with the power of judicial magistrate, first class, as provided under Code of 1973 for trial of offences under the penal code or under any other law for the time being applicable in the Khasi Hills Autonomous District Council. On August 10, 2011, a notification issued under order, so my lord, this is the notification my lord, friend has related to. On August 2011, a notification issued under the order of the governor approved the appointment of a named judge of the District Council Court, Shillong, to try offences punishable with death, transportation for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code or under any law for the time being applicable in the Khasi Hills Autonomous District Council. However, within a short time thereafter, on September 14, 2011, 3 judicial officers in the regular hierarchy of the judiciary and not from the District Council Court structure were invested with the powers of judicial magistrate. Judicial magistrate first class as defined in the Code of 1973 within specified areas. Such notification of September 18, 2011 specified that the notification was in suppression of earlier notification in respect of the same matters within the East Khasi Hills district. However, the notification of September 28, 2011 referred to the said rules of 1937 and the said order of 1950 and also the approval of the Guwahati High Court for its publication, but did not allude to the 6th schedule to the Constitution. On May 29, 2014, under orders of the governor, a further notification was published in exercise of authority under 1937 rules and the Meghalaya Autonomous District Administration of Justice Act to separate the judiciary from the executive in the West Khasi Hills district. By such notification, the district and session judge Nongstoin was appointed as the additional deputy commissioner, West Khasi Hills district, for the trial of all offences punishable with death, imprisonment for life, or imprisonment for a term not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district except the Mairang Civil Subdivision. Now, paragraph 16, my lord, their contentions have been summed up, my lord. Lordship will find this has been the main things. It is such notification of May 29, 2014, the appellant questions on the ground that since the Criminal Procedure Code had not been notified in the state at the relevant point of time, there could have been no session division in terms of Section 9 of the Code of 1973 and as a consequence, no position as a district and session judge. The second ground of challenge is that since the power to try criminal cases pertaining to heinous offence had already been conferred to a named judge by the notification of August 10, 2011, the governor had no residuary authority to carve out a part of the authority and confer the same on any other officer. My lord, this will take care of the entire issue even before your lordship, my lord. The reading of paragraph 5.1 of the 6th schedule as per the appellant is that all the power has to be conferred on one court, my lord, or officer and not divided and conferred on various courts or officers. The last limb of argument, though somewhat facetious, is that there is a distinction between a court and an officer in paragraph 5.1 of the 6th schedule of the Constitution. It must be pointed out that the notification of May 29, 2014 clearly stipulated that such notification superseded all earlier notification in respect to the matters covered thereby pertaining to the East Khasi Hills district. To maintain their continuity, there is then a notification of March 17, 2015 by which a named additional judge of the District Council Court in Shillong was conferred the authority to try cases of heinous criminal offences. The next notification is of December 20, 2015 by which a named judicial officer designated as a district judge was appointed as additional deputy commissioner in Rivoi district for trial of all heinous criminal offences. The notification specified that the authority exercised by the governor was in terms of rule of 1937, the Act of 1960 and para 5 of the 6th schedule to the Constitution. The notification further indicated that it was in suppression of earlier notification pertaining to the relevant provisions within River district. According to the appellant, in view of the 6th schedule to the Constitution envisaged the district council courts taking up all disputes between a tribal and another tribal within the jurisdiction of the district council court in the same area, and since by a previous notification of August 10, 2011, the governor had conferred full authority to a named judge of the district council court in Shillong, the subsequent notification of December 10, 2015 was an anomaly. The appellant also submits that the invocation of the authority of the governor under paragraph 5.1 of the 6th schedule to the Constitution is flawed. To boot, the appellant maintains that since a particular judicial officer was named in the notification of December 10, 2015, whatever authority was legally conferred by the notification was limited to the named officer and could not be exercised by a successor in office. The last three notifications are of February 12, 2016, February 7, 2017 and May 3, 2018. A list of such notifications pertain to the trial of heinous offences in the West Jaintia Hills district. The second of the notification pertains to an additional judge of the District Council Court at Shillong. The third and the most contentious is the notification of the May 3, 2018, in pursuant whereof the criminal trial of this case was conducted. The notification may be seen in its entirety. In exercise of the powers conferred under Rule 1A of the Rule of Administration of Justice and Police in the Khasi and Jaintia Hills, 1937, and further under subsection 1 of section 2 of the Meghalaya Autonomous District Administration of Justice Act, read with para 5 of the 6th schedule of the Constitution of India, is pleased to confer the district and session judge Revoi with powers of additional deputy commissioner, Revoi district, for the trial of all offences punishable with death, imprisonment for a term not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district, and also to hear all civil and criminal revisions, appeals, etc. from the decisions of the assistants to the deputy commissioners within the said district, and the governor is further pleased to direct that such district and session judge as additional deputy commissioner shall, for the purpose aforesaid, exercises all the judicial powers of the deputy commissioner within the said district with effect from the date of joining. This supersedes all other notification issued to this effect under the aforesaid provisions within the Revoi district. Well, this notification was particularly referred to, my lord, just to show that the courts there were having the power, my lord. The courts where the trial was held, my lord. The judgment of conviction in this case was pronounced on December 6, 2019, and the sentence was also read out on the same day. Two important factors must be kept in mind. The first is the gradual and delayed transition of judicial authority from executive wing to courts, be it to the district council courts in accordance with the 6th schedule to the constitution, or the regular judiciary, or otherwise envisaged in the constitution derogates the 6th schedule thereto. The second aspect is in the seemingly parallel but not overlapping functioning of the district council court and the regular judiciary in the state, which is almost entirely covered by the 6th schedule. A short but substantial answer to the doubts raised by the appellant herein would be to refer to de facto doctrine, since, my lord, this paragraph may not be relevant for this purpose because their trial was conducted and sentence was pronounced, my lord. But even then, my lord, I am just reading it. Here would be to refer to de facto doctrine, since irrespective of their technicalities and perceived anomalies that the appellant cites, the real intent and purport of the law through the various rules, orders and notifications have been to confer authority for the trial of criminal cases by carving out a niche in respect of special matters referred to in paragraph 5 of the 6th schedule to the Constitution. Further, the application of the de facto doctrine in this case appears to be appropriate, since it is nobody's case that serious criminal matters were heard by doctors or accountants or by judicial officer not of such experience or standing as would be in keeping with the spirit of the Code of 1973. Well, this also has some relevancy so far as the, my lord, the background of the courts are concerned. Now, there is, however, a more substantial answer. But therefore, before spelling it out, a recent healthy development is in establishing the majesty of the rule of law in the state must be noticed. It is heartening that in furtherance of the rapid strides all round that this state has made in recent times, the Code of Civil Procedure 1908 and Code of Criminal Procedure 1973 have now been notified in the state by separate notification of September 20, 2022. The notification issued under the authority of the governor in exercise of the power conferred under section 1-2 of the Code 1973 set out. Now, my lord, I don't think it is required to be read, but the lordship desires, I can read it out, my lord. In persons of full separation of the judiciary from the executive, and in exercise of the powers conferred in proviso to subsection 2 of section 1 of the Code of Criminal Procedure 1973, the Governor of Meghalaya is pleased to apply the provisions of the Code of Criminal Procedure 1973 to the courts in the state of Meghalaya. The District Council courts shall continue to derive powers under paragraph 4 and 5 of the 6th schedule to the Constitution of India. The Governor of Meghalaya further directs that notwithstanding such application, all actions taken by the courts throughout Meghalaya under the rules for administration of justice and police in the Khasian Janata 1937 and the rules of administration of justice and police in Garo 1937 shall be deemed to have been taken under the relevant provisions of the Code of Criminal Procedure 1973. Almost as an aside and before dwelling into the legal issues that have been raised by the appellant, it may be observed that while the state may lack in development in terms of healthcare, education, employment, industry and certain other facilities, the citizens here can no longer be said to be backward for or indulging in such practices as would rule out their integration into mainstream society, as was rather uncharitably perceived while leveling parts of the state and the entire northeast in general as backward areas and partly backward areas. It is true that the happy people of the state of Meghalaya love and worship nature, but they also avail of the latest benefits in formation of the technology and FMCG. Penetration is up to the last mile. There is no longer any primitiveness about the inhabitants of the state, though they yearn for all kind of development that the rest of the country has experienced, much as the other seemingly neglected regions of the Northeast. In short, integration into mainstream society is complete. Any assessment of the doubts and issues raised by the appellant herein has to begin with a reference to the two key paragraphs of the 6th schedule of the Constitution. There is no doubt that para 4 vests the administration of justice in autonomous district with the district council courts, but such authority comes with two caveats indicated by the expression between the parties, all of whom belong to scheduled tribes within such areas, and other than suits and cases to which the provisions of subparagraph 1 of paragraph 5 of this schedule apply. The word cases in the second expression would take within its fold all matters covered by paragraph 5.1 of the same schedule other than suits. Paragraph 5 of the 6th schedule to the Constitution makes a clear distinction between other criminal matters and criminal matters pertaining to the trial of offences punishable with death, in transportation for life, or imprisonment for a term not less than 5 years. In respect of such serious criminal cases pertaining to offences under the Penal Code or any other law applicable to the relevant district, the governor is empowered to specifically confer authority on bodies and persons. Now, this may be taken. Such authority may be conferred on a district council having authority over such district or courts constituted by such district council, or on any officer appointed in that behalf by the governor. Since there is no regional council here, the reference to regional council in this provision is ignored. The last name of paragraph 5.1 of the 6th schedule to the Constitution emphasizes that it is only upon the conferment of authority by the governor in respect of serious criminal matters that the relevant court or officer shall try the matter in excess of the powers so conferred. In other words, till the authority is conferred in accordance with paragraph 5.1 of the 6th schedule of the Constitution, such powers cannot be exercised. That is the only possible interpretation, since paragraph 4 of the said schedule, which apparently confers all powers on the village council and district council court, is tempered by excluding from such authority the jurisdiction to try suits and cases to which the provisions of paragraph 5.1 of the said schedule apply. On the other hand, the authority may be conferred on the relevant district council or courts constituted by the such district council or any other officer appointed in their behalf by the governor. Since it is clear that the authority in terms of the relevant provisions may be conferred on the relevant district council or district council court, it needs to be emphasized that such authority may also be conferred on any officer, provided such officer is appointed in that behalf by the governor. My lord, that to be, my lord, taken note of, my lord. Ignore.
Yes.
Yes, my lord. Ignoring to begin with, the authority which is expressly invoked in issuing the disputed notification, it is evident that in each case the authority has been issued to a particular district council court or to a named official manning a district council court or to a person appointed as the district judge in terms of Meghalaya Judicial Service Rules 2006. There can be no doubt that a district judge being appointed under said rules of 2006 has been so appointed to take up such matters as district judges ordinary would. Again, ignoring for the time being that at the time that the disputed notifications were issued, the Code of Criminal Procedure 1973 had not been wholeheartedly embraced in this state. The constitutional hierarchy of the judicial system, except to the extent of autonomy granted to the district council courts, was the same here as anywhere else in the country, with the district judiciary and its several tiers forming the base. The High Court exercises superintendence over the district judiciary, and the Supreme Court at the top of the pyramid, exercising primacy in all matters judicial. Thus, whether a notification named a particular district judge or referred to the office of the district judge, the conferment of the authority of by the governor had to be seen to be an officer appointed by the governor in that behalf. My lord, that is also, my lord, very important to be noted here, my lord. The fact that since the Code of 1973 had not been notified and session division had not been declared in accordance with section 9 of such code would matter little. My lord, of course, this part will not be relevant so far as the East Coastal district is concerned, my lord, because there is no dispute with regard to the exercise of power by the courts as, my lord, the additional deputy commissioner or deputy commissioner, my lord.
Yes.
Anyway, my lord, I'll just continue. Section 9 of the statute matter. Appointments were made by the governor on the recommendation of the High Court to the post designated as district and session judge, and the conferment of authority by the governor was either to a person holding such post or generally to that office. There is no basis to the appellant's contention that once the authority in terms of paragraph 5(1) of 6th schedule to the Constitution is conferred on a court or an officer, the governor has no residuary power to carve out a part of the authority already conferred and vest the same in some other courts or officer. Indeed, reading such limitation would defy logic and would be an anathema to an efficient justice delivery system. For example, in a particular matter, the judge manning the designated court or the named officer conferred the authority may desire to be recused. If the argument put forth by the appellant were to be accepted, that would imply that the particular matter could not only be assigned to any other court or officer, and that would go against the grain of the paragraph 5(2) of the said schedule.
Yes.
It cannot be said that the authority to assign a particular matter to another remains in some situations, and such authority is not generally available, unless the governing provision specifies as such. If there is the authority to assign a particular matter to another person or forum, it must be that there is general authority to carve out a portion of authority already conferred to bestow another with the same. Now, my lord, going by the same logic, my lord. Now, if supposingly, my lord, as we have seen the words in the 6th schedule, that it starts with governor may. Now, the exercise of discretion. Now, my lord, if situation comes, if the governor for some reason doesn't confer, my lord, that authority to the courts of district council or any officer under it, would it mean that the criminal justice will come to an halt so far as the offences, my lord, where the punishment is more than 5 years, 5 years and above? This cannot be, my lord. Similarly, there is no limitation on the powers of the governor in conferring a part of the authority, say pertaining to the penal code, to a particular court or officer appointed in that behalf, and some other special law to a special court or officer appointed in that behalf. The plain and wide amplitude of paragraph 5 of the 6th schedule to the Constitution cannot be seen to be hedged with such onerous condition as the authority being required to be conferred on one court or officer, or the authority once conferred not being capable of being modified in part to carve out a class of mates to be placed before an altogether separate court or officer. An unsubstantiated factual submission has been made on behalf of the appellant to the effect that despite the notification of December 10, 2015 and May 3, 2018, other criminal matters within river districts pertaining to serious offences where the victim and the accused are tribals and the offences may have been committed within the jurisdiction of the relevant district council court continue on the board of the district council court. Since such factual assertion has been made deep into the hearing and just before arguments being closed, the state has not been in a position to respond and confirm what the appellant has claimed. However, in view of the second paragraphs, in both the notifications of December 10, 2015 and May 3, 2018, the earlier notifications pertaining to trial of serious crimes within River district stand superseded, and the power previously conferred to the district council court or particular officers can no longer be exercised to the extent that it has been superseded. The other unremarkable point made on behalf of the appellant pertains to the indication of the source of authority in the several notifications referred to herein. While in the ideal situation, the statute and provisions conferring the power and the extent of such authority may be quoted while issuing notifications conferring jurisdiction, the fact that the power to publish a notification is not indicated or an erroneous provision is quoted would make no difference as long as the power to confer jurisdiction is there. There is no doubt that the power under paragraph 5(1) of the 6th schedule to the Constitution permitted all the notifications referred to herein above to be issued irrespective of whether such authority was indicated in the particular notifications or the power invoked for such purpose was erroneously traced to some other rule or order. Whether under rules of 1937 or under the subsequent rules or finally the Constitution, it is undeniable that it is the governor who has the authority to confer jurisdiction on courts and officers for trying serious criminal matters. Well, that may be taken note of, my lord. As such, the faulty nomenclature, the inappropriate invocation of power, or the complete failure to indicate the authority for such power, if at all, pales into insignificance, as it is evident that the governor possesses the requisite authority to direct the issuance of the relevant notifications. Finally, there is an imaginary ghost that the appellant finds to be lurking in the second paragraph of the recent notification issued to make the Code of 1973 applicable to all criminal matters in the state. The appellant apprehends that such second paragraph is a disingenuous provision mischievously included in the relevant notification to regularize the trial and adjudication of all criminal matters that may have been conducted without jurisdiction as canvassed by the appellant in the present case. Since no irregularity, far less illegality, has been found in the conduct of the criminal trials as in the present case, the validation of trials conducted in this case need not be on the clutches of the second paragraph of the relevant notification of September 20, 2020. Though it is not necessary to look into the basis for including the second paragraph in the said notification, prima facie it appears to be by way of abundant caution. At any rate, the jurisdiction of or efficacy of the relevant paragraph may be more appropriately assessed when it is pressed into service. In the present context, it is wholly immaterial. For the reasons aforesaid, there is no merit in the objection raised by the appellant as to the jurisdiction of trial court in this case to conduct the criminal trial, adjudicate the matter, and pronounce its judgment and order therein. In terms of notification of May 3, 2018, the office of the district and session judge, as specified in the Meghalaya Judicial Institute 2006, was vested with the power to try the present case as it involved a death sentence and appellant's challenge to such authority is made. My lord, then subsequently from paragraph 13, my lord, it concerns the merit of that particular case. Now, my lord, the challenges which you have made, my lord. The first thing is that once there is authorization to the district council court under paragraph 5(1), my lord, and where parties are tribal, my lord, in such a case, my lord, that this is not tribal by any other court, or the power cannot be conferred to any other court, or cannot be accessed by any court, my lord, that has been indicated, my lord. Now, their second contention was is that, my lord, that in that the River district, my lord, that the power was not the court below who had conducted the trial had, my lord, no authority to do so, my lord. So that also has been rejected, my lord. But so far as Iskasi district is concerned, my lord, I don't think that second contention is there, my lord, that the court of the session judge or additional deputy commissioner had no power at that point of time, my lord. It is not the case, my lord. Here only, my lord, two things, my lord. The only thing is that is, my lord, matter basically comes back to one position, that the matter between tribal and tribal falling under paragraph 5(1), whether it is exclusive jurisdiction of district council or not, my lord. And that issue, my respectfully, my lord, it has been answered, my lord, adequately, elaborately by the division bench order, my lord. And my lord, there is, my lord, I don't think any other requirement to, my lord, venture into other areas, so long this judgment remains, and my lord binds us.
Where's the notifications implementing CRPC and CPC?
2087.
I'll give a reply with this.
Yes.
Now, my lord, lordship, my lord, I have seen in certain case, my lord, the decision of my lord, that's Malvin
So long Pio
was referred, my lord. My lord, especially I think, my lord, where the my lord, senior counsel Mr. Kinjing was appearing, my lord. Now, my lord, in the judgment also, lordship, my lord, if comes to my lord, I think the judgment is before lordship, my lord. Whether it is there or not, I can supply a copy, my lord.
Yes.
My lord, here, my lord, the primary issue in that case, my lord, before the apex court was that whether, my lord, the state would be regarded as tribal or not, my lord. And, my lord, the matters were investigation conducted by the state. Even if, my lord, if the accused and the victim is tribal, my lord, whether that can be before this court or not. And two things, my lord, whether the term case.
Is it reported, this case?
Well, this is reported, my lord. This is 2023 SCC.
Just give the citation.
My lord, I can give you judgment.
Yes, I don't have the reported one. This is just a printout.
No, my lord, this is a reported one.
Yes. Still 20 years. Yes.
No, lordship, my lord, I draw your lordship's attention to, my lord, paragraph 8, my lord. Under Schedule 6 to the Constitution, para 4 and 5 deal with the administration of justice in autonomous district and autonomous regions. The district council or regional council, as the case may be, with the power to constitute courts to exclusively try suits and cases where all parties thereto belong to scheduled tribes within such areas. This, however, does not apply to those suits and cases that are covered by para 5.1 of the Schedule 6, wherein the governor may confer on the district or regional council or the court set up by the district council or on any officer appointed by the governor in that behalf such powers under CRPC or the Code of Civil Procedure as the governor deems appropriate. Further, para 4.4 stipulates that courts set up by the district council are to function in accordance with the procedure evolved in these rules made by the district council of the regional council, as the case may be. Now, my lord, this has been made clear that 5.1 is separate.
Yes.
That is what, my lord, I tried to point out, my lord. And, my lord, there is a reassertion of the same in the paragraph 10.4, my lord, also.
Yes.
So, my lord, in that view of the matter, my lord, there remains nothing, my lord, in these sets of petitions, my lord, to be considered.
In this case, what was the offence? It's under 5 years. It's so long pure?
No, my lord.
It's beyond 5 years, my lord. Beyond 5 years. Session Court notes when was trying the case, and the petitioner sought for transfer. And this one could allow that petition.
agree with that state went for appeal. The Supreme Court rendered this judgment.
Now come to 10.6. 10.5, on the 10.6.
No.
Look, regard 10.4 speaks of such a reading of term cases is also substantiated by the fact that para 5 only empowers the governor to make CRPC applicable to those cases where the punishment for the offence not less than 5 years under IPC. By this implication, then the governor is not authorized to invest any of the bodies mentioned para 5.1 with the powers under CRPC for offences where the punishment is less than 5 years. That means officers notified will go to the district council courts, notwithstanding the fact that the state is a complainant. In conjunction, reading para 5 in conjunction with para 4 inevitably leads to the conclusion that all criminal cases are tribal by courts constituted para 4 jurisdictions, irrespective of the fact that de jure complainant is a state, as long as the board accused the victim belongs to the same scheduled tribe. That is a settled position. Now, but this position that now this was held in 10.6 and 11. That means that it's before the notification.
Supreme Court context would be different, my lord. It was primarily concerned with the issue, my lord, whether the state would be a tribal or not, my lord, where complaint is taken, my lord.
No. You see, the thing is that now the conclusion, in view of foregoing, we don't find any grounds to interfere with the judgment in order dated 5/12/2017 passed by High Court of Meghalaya, inasmuch as the High Court was justified in transferring the criminal case against the accused respondent from the Court of Sessions Judge Downstein to the Court of Judge Council, so and so.
Well, it was challenged on two accounts, saying that state would not come under the category of tribal. And second thing, my lord, the term case, as used in para 4 of the schedule, my lord, this will not include the criminal trials, my lord. These are primarily two grounds which were taken, my lord. By the state before the apex court, which are negated.
Interesting.
My lord, sometimes it becomes a bit confusing also, my lord.
Very confusing. This judgment is very confusing. Because with due respect, I don't think it lays down the correct proposition. Though they've given a finding in para 8.
No, lord.
What is the division bench judgment does not discuss this?
It was not referred at all. I do not know, my lord, why it should have been. This should have been referred, my lord.
Will it call for new reference?
My lord, again the line on which division bench are divided, my lord, this doesn't find place here in this case. It has not taken into consideration all those aspects which the division benches are taking into consideration.
Of course, but this that you see, it would be to distinguish.
My lord.
That should have been distinguished. That how does judgment not cover? Because this oversimplifies the issue. This with due respect again to
My lord, I also understand, my lord. That is why I say, my lord, it becomes quite confusing also.
Oversimplifies the issue.
No, my lord, even if, my lord, even if lordship finds that, my lord, there is something, my lord, will it be appropriate for this to take a, my lord, view which apparently, my lord, my lord, goes with the same view, my lord. If it is to be, my lord, separate views to be taken, then again, if that is the thing, my lord, of course, my lord, I would respectfully say that yes, paragraph 5.1 doesn't exclude adjustment. That is the reference to the provisions of schedule itself is enough.
No, if it has been, they have been interpreted in the correct light in view of the developments that happen now, especially after the invocation, of the of CRPC and CPC. So that is the only thing. That's the only troubling thing is para 11. Where the judgment of the High Court, 2017?
The Solomon case.
Yes,
Solomon case was delivered on, my lord, 5th December 2017.
So you have a copy of the judgment?
But the downloaded one, I have the copy. It is.
It's also reported, I think.
Must be reported, yes. Can you give the citation?
No, I'm sorry, this is delivered by the Supreme Court. The High Court one, I don't.
Reported.
Reported. Okay.
High Court.
High Court.
High Court.
Can I have both court?
To refer, you can give me back after some time. Can we permit to sit for a moment?
Yeah, of course, please. That is actually at your discretion.
I am just
Because see, by reading the division bench judgment, everything is clear. But by reading the other parallel judgments, then
this will be a tough one, your lordship. Call on your lordship, my lord. This will be quite tough for your lordship to take a view, my lord.
especially sitting in single bench.
My lord, definitely.
Why it does not brought a notice of the division bench judgment?
My lord, with due respect, I place this judgment before the learned division bench. Learned HG advanced argument that this judgment rendered in Solomon Bell is not applicable.
In which manner? The finding there is applicable, notwithstanding what are the reasons.
My lord,
yes.
that was his argument, and subsequently, my lord, the judgment it is not reflected there. Otherwise, I relied.
It's not applicable.
No, I relied it is applicable.
No, that's what the Advocate General said.
My lord, Advocate General said that with regard to Ripoy district, it is not. My lord, after learned EHG finish, I'll just give some clarification. Lordship permits me.
I think you'll have to continue another day. I don't want to look at the judgment list. We will continue tomorrow. Yes. Is hearing inconclusive? Yes. This again tomorrow. Yes. In the supplementary causes.
Main list, item 24.
You've made a copy?
Lordship,
I received it.
I have compiled chronologically, it's there on the record. I have supplied the copy.
I got it today.
Where is it? Take it out. Mr. Gurung.
On 20th July we had filed it.
But they said it has not been supplied.
I got it today, my lord.
It's not here with the group. Who did you give it to? The court master or did you give it to?
Filing section on 20th July.
Else the matter may be taken up day after, my lord.
You filed an affidavit.
Lordship, yes.
Affidavit you filed. Why day after tomorrow, Mr. Prasad? I want to reserve it for judgment. Okay, day after tomorrow is this one. Who's Jethaba?
My assistant.
He filed it.
Malik.
This is this, okay. Where's the PT Samaj? Right? Okay, we'll have it day after tomorrow. We'll pass orders. Day after tomorrow is Thursday.
Thursday.
Well, there will be hearing, my lord, on Thursday.
Yes? We'll 5 minutes hearing. We'll have to pass some orders.
No, because from our side, the submission is left.
Either finish his submissions.
We have not given
okay,
any
day
submission.
after.
The submission is given by
additional affidavit has been filed by the petitioner, bring on record the all the relevant material with regard to the service of the petitioner. Stop.
Service record.
Yes, service of the petitioner. Yes, this is a matter thereafter as prayed for by Mr. T. Varchari and the GA.
Because our submission is
for the hearing is.
Actually, Lordship, it was heard again and
From our
again,
side
even
it
from
was
the
not
state
heard.
side. But in this case, what had happened?
No, Mr. P.
The state council had been changed.
No, Mr. P. Sama, he played trump card. Everything went haywire. Yes.
31.
Deployable.
What's the response?
Yes.
May it please, Lordship.
How long will it take to finish the law?
Not take much time, Your Lordship, because with respect to some of the question of law, I have a present for the court and answered accordingly.
Yes.
And Your Lordship, as of at present, I would like to bring Your Lordship notice to page 495.
495?
195.
Are these additional documents you file with this, which is a gift deed and this and that?
That's
what
a
are
plain.
these?
I'm referring to the impugned judgment.
Right. 195.
195, yes.
Yes.
Your Lordship, the main issue and controversy in the suit is with respect to the eviction. Your Lordship.
With respect to the?
Eviction. It's an eviction matter. So, Your Lordship, certain observation was made by the learned First Appellate Court with respect to certain issues which neither the learned court below has dwelled on it. And it has been reflected in the judgment, Your Lordship. Okay. And the matter, an issue and controversy is with respect to, may I read, Your Lordship?
195?
195, yes. I'll read, Your Lordship. That having heard and produced the written argument of the Land Council for both so-and-so, along with the memo of appeal, with the next disclosed material in the court, it is found that the appellant is a tenant of the respondent, and the same was never disputed by the respondent. Further,
You are the appellant in the lower court.
Your Lordship, as of at present, the matter before the trial court is pending.
No, you are the appellant before the trial court.
I'm the respondent.
Okay.
I'm the
You are the
respondent.
rear tenant.
I'm the plaintiff in the.
Okay.
I
The
filed
appellant
this-
is
I
the
presented
tenant.
this
Okay.
suit, yes. So, Your Lordship, this is the matter in controversy. Till that stage, when the appeal was filed for, it was basically on the issue of the application file under 151. Your Lordship. So they have brought many records, many documents more related to in the appeal that they have preferred We have, and so far as concerned, the issues has not yet been framed. As at that stage before the trial court, Your Lordship, they have not filed the WS. And we came later on to know that they have filed, which we have never received the copy.
Till date?
Yes, Your Lordship. So the matter in controversy is still lie, the jurisdiction and power still lie with them.
Why is come up in second appeal? Just for literal correction?
No, Your Lordship, because that little connection, but the matter which I have preferred for, because they have filed multiple applications under section 151 CPC. So that is the issue that have come before this honorable court. So with respect to which the question of law which has been framed, I have submitted to Your Lordship. There are certain questions which have been put for. I have apprised the court on.
No, you read 195. What do you show from here?
From here, Your Lordship, because of the issue and controversy which jurisdiction lie with the trial court, but the observation is made by the appellate court, the first appellate court, Lordship. Now this will bring the entire suit in a different manner. It will change the entire thing, and it will bring in it has created a right for the tenant to occupy the rented premises infinitum, Lordship. The eviction, the agreement which they have executed has already ceased, Lordship. There's no more an existence of any of the tenancy agreement. So for the reason why I have instituted the suit for eviction against the respondent. And Your Lordship, here another issue which...
No, one thing, Mr. Big Dog, just coming back.
Yes.
Now the only issue is the electricity connection. Where it's come up here with this repeated application.
No, it's not a matter of electricity connection, Your Lordship. It's a matter of presentation of application number 151, as of apprised, Your Lordship, at the initial stage, Your Lordship. So as of now, with the matter connection with the electricity, it has been resumed. We have provided electricity, Your Lordship. So the matter in controversy, Lordship, as I have raised in one of the judgment which Your Lordship has question on the maintainability, which this should have come as a revision. But I have relied on the judgment by the Honorable Supreme Court as well, Your Lordship, that if observation may be made on this issue with respect to 151, where inherent power of the court should be exercised when there's no other remedy. But when there's a remedy, they did not go for in accordance with law, but they have filed multiple applications in the 151.
Yes, okay.
So, Your Lordship, can I refer to the question of law which I have?
Yes. Now the only, at the lower appellate court, the appeal was admitted, it's lying there. What
no, it's already disposed of, Your Lordship, by deputy order.
Okay. No, but why? But the instant appeal is merits consideration seems often admitted, and case stands disposed of.
Yes, Your Lordship.
So the whole matter was heard at the before admission only.
Yes.
Very strange. See how it ends, the order. Page 199. See, admission of appeal means like on consideration of prima facie, like whether, I mean, like whether grounds of appeal been made out, then you admit the appeal. Not that the instant appeals merit consideration seems only admitted, case stands disposed of.
Maybe there is a slight mistake, my lord. But then the appeal was disposed of.
Okay.
Finally, after being heard by both.
Of course, that's why we won't come second appeal here.
My lord.
Yes. Yes.
Your Lordship, the question which I have put for Your Lordship, whether the appellate court can decide the miscase in isolation when Order 8 of CPC is not complied with by the respondent. So, Your Lordship, this only
which issue?
Number 4.
Yes. Okay, yes.
Yes, Your Lordship. This maybe.
My lord, before he proceeds further, I would just like to mention, Your Lordship, he has challenged this order before this appellate court. He has challenged this order. Impugn order is this, and he is referring to the different orders, which has already attained finality.
No,
that was never challenged.
Let me complete at least my submission.
No, because you're confusing the court.
No.
Court is getting confused.
How did the court get confused?
My lord, the impugn order, he's not speaking about impugn order.
He's talking about proceedings.
Impugn order has nothing to do with Order 8. Impugn order is basically, my lord, for restoration of electricity in the premises.
To submit on that issue.
Submit.
Your Lordship. My humble submission is, Your Lordship, in connection with this question of law that I put. We came to know later on that the written statement has been filed, Lordship. So this question of law may be skipped That is my intention, so to say now, because it has come
Number
to
4 we skipped.
Yes, Your Lordship.
Okay. Yes.
So, Your Lordship, and number 5, whether the appellate court can appreciate and accept documents required to be examined by the trial court at the stage of evidence in eviction suit number 2 of 2019. So, Your Lordship, my main contention here with respect to the appeal that I have preferred before the first appellate court, they have brought new documents which they have never relied.
They brought new documents in the appellate stage.
Yes, Your Lordship. Which is, they show the receipts which they have purchased.
One thing I want to, this court wants to know is that, what did we file as a statement? Before you filed appeal or after?
I have filed my written statement.
When did you file appeal?
Appeal was filed, my lord.
Date?
Much after the written statement was filed.
Is that correct?
Yes, my lord. This is
records are here.
Records are.
Written statement was filed in the month of March 2021.
We'll take your word for it. March
2021.
Which the exact date? No idea. And this is date 20th May. Record of appellate court and trial court. I think it will take some time to think though. It's just because he's you said March, correct?
Yeah. March.
Suit was filed in 19, you filed it in 21.
Suit was filed, yes.
Your Lordship,
there was a...
In connection to this matter, also we have filed an application.
No, they have filed now in 23.
Your Lordship, I think, Your Lordship, may I make a suggestion? Your Lordship may kindly peruse the entire record of the trial court as well, because there are various applications which we had filed for closing of the filing of written statement.
You filed it on 8th of April 2021. Your written statement. The copy is not received. That the plaintiff received copy. 63621 says issues and documents. Here's put up before you notice the both parties, the appearance. Next date, same orders and statement. Both parties. Miscase has been heard, no?
No, Your Lordship.
We will truncate the proceedings and send it back. There's only ways, and you have to just streamline the proceedings. Would it be better if it comes to 227?
Yes, Your Lordship.
Anyway.
Your Lordship, I mean, I pray if it may be.
Doesn't matter. We didn't. $7.5. Appellate court report. Let's do that once. Now, where are the other miscases? They're together with the records. They're all here. Only the title suit is there.
What
about the injunction application is separate?
Yes,
There
it's separate.
again, there's a history, my lord. That injunction
No,
order.
I think, Your Lordship,
no other applications are there on record or not? Have you record been? Because the thing is that this appeal is against the against an order passed in this application number 321, arising out of this case. The trial court this case where the property situated?
Lime Crown.
Okay, come to the next issue. Because your main grounds is that the judgment of the appellate court has given a sort of finality to the entire without issues being framed or without the other substantive matter being gone to a trial court at evidence stage.
Yes, Your Lordship.
By accepting the documents which the
appellant
there, I mean the respondent here had filed before the yes, okay.
So the other contention, Your Lordship, of which the appellate court has touched into the controversy of the suit, Your Lordship.
That's what you think is the
yes. So
and in such a manner it's affected the
yes, Your Lordship.
Yes.
Generally, in every eviction suit, once a tenant, Your Lordship, they want to apply at infinity. So, Your Lordship, as in this case, Your Lordship, the time bar was there for filing of written statement. May I brought Your Lordship kind attention that we have filed an application
for rejection of written statement.
Yes.
But was the order? Did you file an application for extension of time for written statement?
They never prefer any application. They never.
Yeah, the suit was filed in 2019.
Yes.
2019, correct. Has that matter been decided? No.
No.
This case is to go back. Let's just see. You keep it then restored doesn't matter, but it has substantially has to go back and proceed on on an even keel. The thing is that you have resorted to very what do you call it adventurism, in the sense that without filing a statement you file successive miscase under 151. Right, to somehow guard your possession.
Subject to, my lord, I will make.
No, I mean, why have you filed miscases then? Even for LSC connections or anything, it is at the trial court level itself. If you want to file any business applications under Section 94 or under any other provision, you can have filed. You could have filed it for other interim relief.
No, my lord.
Now, what made you file an appeal?
No.
What made you file is repeated miscases then? On 151. Why didn't you file a statement within time?
written statement, my lord, was filed in the year 2021.
Yes, we got the date 8/4. You said in 20. You said
That was
March.
the-
It's
there
fine
was
in
a
April.
there was a reason, my lord, for that.
That reason has to be gone. Not here. The reason has to be
True, my lord.
has to be
Why written
agitated
statement
before the
was
trial
I
court.
was abstained from filing, my lord, was only because of the reason that initially they have suppressed all the facts. Initially they filed a eviction suit, my lord. They did not file any miscase for injunction.
How
No-
can you file a miscase injunction? Can an injunction be given eviction
Exactly.
suit?
That is that is
no,
the point,
listen,
my
Mr. Mansoori. If you are in possession,
Yes, my lord.
can injunction be given?
That was given. That was given, my lord. That is what I want to highlight, my lord. No,
Your
so
Lordship,
illegally.
on this
they come
ground,
up-
they have
Please,
changed many councils, Your Lordship.
Please, let me.
But
No,
the
don't
matter
fight
now,
my conscience, yes.
matter now
No,
is
no,
under
the
status quo.
You mean to say that you filed an application for injunction against them entering the premises and it was granted?
Yes.
It was vacated later on.
Yes, not later on vacated. I
Yeah.
was
And Your Lordship,
locked.
you see, Your Lordship, for this issue,
It was locked.
Miscase 48 is
I
still
had to-
pending.
I was compelled to
this
go for
reason.
appeal, my lord. I was compelled.
But they never
by
challenged
virtue
the
of
Miscase 48.
they have
Interesting.
by virtue of that they have
We'll
closed
have
my shop.
it again after 1 week. Yes.
They have closed
no,
my
but then
shop.
you come prepared.
If
Now
I-
we have time. Yes.
My lord, if I place the entire facts, it is so interesting.
Your Lordship,
They-
the record is
it
here.
is other way
Your
around.
Lordship is before Your Lordship.
It is other way around, my lord.
No, usually you cannot grant injunction.
Injunction in eviction suit, my lord.
They never
You're asking
challenged
for-
it before
you're
the
asking
trial
for
court, Your
restoration of
Lordship.
possession.
Why will I challenge
So
it?
there's no question of injunction.
Yes.
That is against all canons of any kind of.
Yes, Your Lordship, but this is the matter in controversy which they ought to challenge before the trial court.
No, why
But they
will I
recently
challenge
issue
it?
now.
No,
They
same
never
court-
appeared for Miscase 48.
They never challenged that injunction.
Of course, I have
No,
challenged, my lord.
no,
in
Your Lordship.
appeal, there is an order of appeal. Appellate court has set aside
they
that.
filed a review.
No,
They filed a-
appeal is filed. I will
But
bring
if
all the
I review
facts,
for
my
the trial
lord.
court,
Yes, and it was
Interesting.
status quo was given. Your
this
Lordship,
court will
as of
document,
at
it will
present.
document his entire adventure.
He's misleading on those facts. And Your Lordship, may I apprise? They have changed counsels and they have preferred an appeal.
Counsel
Basically,
changes-
Your Lordship, at first appearance, when they did not file a written statement. They file an application under 151 and relying on all the documents. I raised objection, it was rejected. And then they prefer an appeal on the first application which they have filed under
So then now
151.
you make a list of that. You better make a concise list of,
Yes,
of
Your
like
Lordship.
the plaint filed by you and your miscase also, right?
Yes.
And then what miscase was filed by you for rejection of the written statement or miscase filed by them or for review or whatever order, just
Yes.
make a list so that this court at least have a
Clear
Yes,
picture.
Lordship.
very interesting.
I will. I have
all
already-
timeline, Your Lordship, of how they have approached
Yeah,
before the trial court.
right. Next matter.
I'll oblige.
Very interesting. Yes, Mr. Deb.
The matter could not be settled, Lordship.
Why?
My Lord, we are willing to settle the matter, but they are adamant that they will give a pinch of the share.
Pinch of what?
Pinch of the share only.
What
they
we
are saying.
What we were saying is, because they're saying that my husband, late husband, was maintaining under some order of the court. So we were saying that we will continue to give you that amount. But she's saying that no, I want 50% of everything. So we were saying that since you...
What was the maintenance amount you were getting?
7,000.
It's a huge amount, you alone, correct?
But in the mediation, so far my...
Who was mediator?
Mina Kharkoma.
Where's the mediation
Kharkoma.
report?
My Lord, it must be.
When was this report? Oh, since 8 April. Yes. Then we'll hear the case on merits.
Yes, my lord.
As the matter cannot be settled out of court, this seems to be heard in merits. Just after 2 weeks. Yes. Why you didn't say at that time that the mediation didn't work out? Or you were not present? You were taking repeated adjournments.
No, Your Lordship, I have already submitted that the matter was not settled.
Yes.